Under compelling circumstances, I know today is original cited. Yesterday, my matter is item number 26. Now, on the basis of submission, which is absolutely incorrect, made by Senior Advocate Joydeep Kaur, matter was disposed of. That is a garden-rich matter. Now, my prayer and the prayer made by the Rakesh Singh, one of the political person, absolutely different.
No, we have not disposed of.
No,
Monday it will come.
Oh, it will come Monday, not disposed of. I was giving impression. I'm extremely sorry, my lord.
No, Monday it will come.
Lordship.
May I have my lord's kind leave to mention an appellate side matter. It's item 31, my lord. I know lordship won't be taking up appellate side. This is the matter where, my lord, the incentive scheme, in terms of the scheme, I already have an order for disbursement. Lordship had asked us to make a request. We had filed an enforcement application before the trial court. And since the bench requested us, my lord, we have been, my lord, seeking time there. That application is listed today. Again, I will take time. I was only praying, my lord, Monday, if it can be. It was item number 3 on 15th of April. And then it was supposed to be listed on
Monday. Only after admissions, because we take up this final hearing matter almost.
My lord, it's for admission.
It's for admission.
Yes, it was item 3 Monday, last Monday. Lordship wanted to take it up next Wednesday because of the holiday, my lord. It was
they'll check up.
Yes, my lord. I'll give the, my lord, particulars, my lord, to my lordship's officer. I would be very grateful if it's up.
Kind leave to mention, my lord, a judgment which was disposed of by my lordship. My lord, there are some typographical errors which are appearing, my lord. My lord.
पोथरा का ये ट्रिब्यूनल ऑर्डर जो आज हाईकोर्ट अपील
My
में
lord,
है
comes to page 5, my lord. I have indicated.
आरती से
My
पूछो
lord, I have
या
indicated.
रोजी से पूछो
Page 5, my lord.
I'm appealing for that.
My lord, in the considering the facts and the assessment is of the year 12-13. The assessment order was
So
passed
it was
on.
not under 263.
It was not under 263, 143.3 assessment, my lord, and the date of the assessment order is 2015 instead of 2013.
But I'm appealing for that.
Matter is shown in the days list under the caption to be mentioned. It is pointed out in the judgment dated 10th April 2024 in page 5. The date of the assessment order and the provision under which the order was passed has gone down wrongly. The said paragraph shall be replaced as follows. Considering the fact that the assessment is of the year 2012-13 and the assessment order was passed on 24/3/2015 under section 143 within bracket 3 of the Act, we request the learned tribunal to give some precedence to the matter so that the appeal can be disposed of at the earliest. This paragraph shall be this shall be incorporated in the order dated 10th April 2024, and this order shall form part of the said order.
My lord, I'm sorry to disturb your lordship. One of the officers of your lordships told me just now, last occasion, that is yesterday, your lordship disposed of my matter on the basis of submission, Mr.
No. Correct. We have disposed it off with liberty to given to you to intervene because the petitioner is an advocate. So you be present on that day and you raise all your grounds, we will consider. Only to avoid multiplicity.
Not multiplicity, my prayer, leaving aside other prayer.
All right, you listed for to be mentioned.
You mentioned. My lord.
Lordship, may I be permitted to mention one Group 3 appeal, my lord, pertaining to determination of the Honorable Division Bench, my lord, presided over by Honorable Justice Surya Prakash Kesharwani, my lord. From today, my lord, since their lordships are not sitting till, my lord, 26th of this month, my lord. My lord, this appeal is pending and was returnable on 17th of this month, my lord. During the pendency of the appeal, when the copies were served upon the ESI authorities, my lord, immediately on the next day,
Next day, what happened?
my lord, they have passed 145A order, my lord. My lord, determining an amount of 19 lakhs and odd, and my lord, if the amount is not being paid.
You have filed an application?
My lord, I have filed appeal, stay application, and after, my lord, receiving the order of.
You include it in the list.
My lord, may I have the liberty, my lord, to mention a matter decided over by the bench, my lord, of Justice Kesarwani, my lord. This, my lord, is an application which has been pending for a while. The only issue is, my lord, consideration of the district magistrate's report regarding permission granted to my client to, my lord, start operation of a mobile tower. My lord, that there was an exception taken. That's the reason, my lord, court directed us to exchange affidavits, my lord. If this application is allowed,
1 week can you wait?
my lord, we have been waiting for last 2.5 years, and my lord, my lord, business has, my lord, come to a stall.
We can't,
If your lordship,
we can't assure you anything, but you please give the letter.
I am grateful, my lord.
My lord, praying for inclusion in the list because it has already filed 1 month back. Still it is not in the list, my lord.
Appellate side matter.
Appellate side matter, my lord.
Inclusion in the list. It says
Inclusion.
1 month before.
Analogous matter, analogous matter.
Your
Grateful,
Lordships,
my lord.
I'm appearing because we have a Ramnavami festival that was happened today on 19th of April. But after giving application on 15th of April, we couldn't get the authority to
You
say
move
yes
the
for it.
single bench. Already single bench is seized of the matters. Yesterday or last week, I think on Monday
It
they
was in
passed
North
an
Chobis Pargana, Sandesh Khali, where
order. This is for Ram.
yeah, North Chobis Pargana, Sandesh Khali. So the candidate from BJP was also appearing for this procession. But the SP and the local police station,
It can't be a PIL. Whoever is the body which has asked for the permission, let that body challenge it. If some club or some
It's a
association,
Vishwa Hindu Parishad.
they file a writ petition, not a PIL. You move the single bench.
Lord, may I have a losses leave to move on urgent application, of course, in the nature of public interest litigation today, if your losses
Today is for not.
then your losses kindly take it up on Monday because of the urgency.
What is the urgency?
I tell you losses, this is in regard to the performance of the Chorok Puja and the Chaitya Sankaranti, we Bengali we otherwise call Nil Sosti. There's a rampant outrage on the particular community by a particular community. And the situation is so tensed in the district of Murshidabad that a particular community cannot go out of their houses or their other areas and perform their performance.
And
The situation,
what day this has to be performed?
Malad, one day in the Chorok Puja day, they're totally vandalized.
No, what is the date?
It's going on, Malad, this Utsav, continuing. It continues. If your losses do that, your loss, and this has become
Serve
a
notice on the government leader's office. Next Monday we will take it up.
do that, your losses. I give notice to them, your loss.
Well, it may be permitted to mention item number 60 of the days list in the appellate side, my lord. Lord, what has happened, my lord, the appellant before your lordship is not being permitted to enter her own home by the, my lord, the other
Monday
members.
it will come up. Monday
My lord, I hand over this, my lord.
not required. Monday
It will be upgraded, my lord.
No, it won't be upgraded. It will come as per serial because admission we can't jump the queue.
May I have my lord's leave to file this mandamus appeal without the certified copy, my lord?
Yes, leave granted.
Grateful, lordship.
With the leave of Justice Bhattacharya, my lord, may I permit to mention, my lord, one matter. Lord, this is a typographical mistake, your lordship order. Lord, your lordship was pleased to, my lord, reject the delay application. But in the first paragraph, my lord, second, third paragraph, we have pursued the affidavit support application. We are not, there will be not satisfied with the explanation offered for not preferring the appeal within limits. Therefore, the delay in filing the appeal is not condoned. The application is not allowed. Thereafter, my lord, but the order has been passed by your lordship and honorable justice, my lord, Supradim Bhattacharya.
Not is missing.
Not in 3 places, my lord, not is missing.
In first paragraph, we have perused the affidavit filed support also, and we are not satisfied.
Yes.
Then with the explanation offered for not preferring the appeal, therefore the delay in filing the appeal cannot be condoned.
Cannot be condoned.
The application is allowed. The application was allowed.
Or application is
Next page it is dismissed.
next paragraph, my lord, application rejected.
They have cut paste it. Sir, please come. Matter has been shown in the days list under the caption to be mentioned. In the order dated 5th February 2024, there are several there's a typographical mistake in paragraph 1. All right. Therefore, paragraph 1 stands deleted and it shall stand substituted as follows. We have perused the affidavit filed in support of the application for condemnation of delay, and we are not satisfied with the explanation of it. For not preferring the appeal within the period of limitation. All right. This order shall form part of the order dated 5th February 2020. Yes, please call.
Conclude.
Please tell Registrar IT that the meeting can be preponed to 4. Yes.
Original cell listed matter item number 1.
I appear for the appellant.
But in this matter, Mr. Tanmoy Mukherjee is appearing for the respondent. Today he has not come to court due to his personal difficulty. And only thing I am saying not today only with consent of the learned ASG.
Lordship's order was of 28th February 2024. Interim order was granted. Yes.
Yes.
Then let it come after a week or some 2 weeks. There's no urgency in them. We have heard the learned counsel, learned additional solicitor general for the appellant. Adjournment is sought for on behalf of the learned advocate for the respondent. This is the matter on so and so date under the same caption. Give a date sometime in June. You don't tell no.
But can it be next week?
No, we'll give a date. Next.
New application text matter number 2.
In this matter, my lord, on the last occasion, the Ministry of Law has already filed a report. Now, I believe that Mr. Shoman Bhattacharjee and Swarajit Rajadi was not very happy with the report. And they wanted to file a rebuttal or take an exception to the report. But now I believe the Ministry of Law has taken a different stand of making the payment, whatever the pending bills. But I am not sure, my lord. This is what I've come to learn from Mr. Tilak Mitra.
The report discloses how and in which manner the payment was made. Now, we all suffer. I had to persuade the Law Ministry at least on 3 occasions for disbursement of the fund. And I am told that during the second week of April, the other funds are released. And not only in this report, which has been disclosed as regards the payment of the claimants, there are subsequently contempt. Subsequent payment were made.
If ASG can interfere and settle it, we will close the matter. There's no problem.
We are all facing the problem. All the Minister of Law and Justice lawyers.
Then we will also take up the case of ASG, DSG also.
Yes, that can be.
We are not on a different boat.
We are all working
together. Difficulty, I tell you, Lordship, what happened. The earlier Ministry of Law and Justice in charge, he requisitioned half of the amount which is required for payment. And that is why the new one had to face the difficulty, and I had to take up the matter with the Law Ministry on 3 occasions. Some funds were released, and out of that, payment has been made. That is disclosed in the report. And these are the other subsequent payments also made after the filing of affidavit and report.
Now, how much is due and payable to all of you?
The difficulty is, the entire issue has now been transferred to the Income Tax Department.
That is that we are taking care of. Separate orders have been passed.
Yes.
They are making online facility, etc.
Yes.
Prior to
Only
19th of April.
prior to the matter going to the Income Tax Department, it was with the Ministry of Law. Only that if ASG can sort out the matter.
Yes, I shall definitely, my lord, but kindly come to page 5 of the affidavit which is filed. What are the payments made and what are the dues?
No, that we have seen that report.
Yes.
Whatever is remaining, if you can finish it by the end of April.
Yes. I shall try, kindly record them.
Only one submission to be made, my lord.
Okay.
Some of the bills are being rejected on the point of the delay, but that should not be, my lord. Because even the bill submitted in the month of November has been rejected on the point of the delay, my lord.
Already paid.
Then you please tell the commissioner that we will.
Not commissioner, the Ministry of Law.
Ministry of
No,
National government.
one difficulty has arisen. The new consecrated in charge, he has been suffering from cancer. He has gone to Bombay, and the other person who is in charge, I am pursuing the matter. Lord, kindly give us within 10th May. 10th May, I shall definitely sort it out.
When
The
sir has
remaining
intervened, we
Kindly record the payments which have been made, and the rest payments shall be disbursed.
when sir has intervened, I do not think we should stand in the way
I think it
anymore.
will be resolved.
Yes.
We have heard the learned standing counsels for the department. We learned the learned additional solicitor general appearing for the Ministry of Law and the learned senior standing counsels / standing counsel for the income tax department. There appears to have been some progress in the settlement of the bills by the Ministry of Law to the learned standing counsels for the income tax department in respect of cases handled by them prior to the jurisdiction being handed over to the income tax department. It appears that certain bills had been rejected on the ground of delay. One such instance being a bill submitted in November has been rejected.
Miller, there is no disclosure of the fact of rejection of bills.
No, that's a submission.
That is their submission.
The learned additional solicitor general submitted that there is no instruction on that regard. In any event, the bill submitted by the learned standing counsel should not be rejected on the ground of delay, as there are several factors which have to be taken into consideration before a bill is raised. The Ministry of Law also should take note of the fact that when the jurisdiction was with the Ministry of Law, with regard to filing of the appeals by the income tax department, several of the appeals were filed with inordinate delay, and even in such cases, the court has exercised discretion and condoned the delay. Therefore, if any bills have been rejected on the ground of delay, the concerned standing counsels are directed to resubmit the bill, and the bill shall be processed in accordance with law. The learned additional solicitor general has assured the court that he will take necessary steps to ensure that the bills are settled at the earliest, and request the matter be listed after 10th May. List the matter on 17th May. You please wait.
Miller only.
Rejection, file affidavit reply against the opposition filed by the Ministry of Law. That will be not filed.
Not required, sir. ASG is
Not required.
Well, the only thing is that your lawsuits have been pleased to direct us to serve all the contesting parties appearing. These are the affidavit of service.
No,
We have served.
No, that we are not objecting to that. We have been served.
Even only thing if I may delete that.
We are happy that
Sir,
court has intervened. That's all.
Claim should be refused on the ground of delay.
so henceforth, all representation will be with the sir only. They will do it. Because ASG is also facing problem.
Common issue now. It's a common issue.
After we separate all your matters, we will take up ASG's matters with
Yes.
so motor matter.
Yes.
Only thing, no bail should be refused on delay because there is.
That your lawsuit has been pleased to record.
It has been
Well, it is returnable on date
17th May.
17th May. Yes.
Deeply.
Next.
Item number 3.
Madam, I am for the respondent SCC, madam.
And for the appeal.
Madam, I have just now received the copy of the appeal, madam.
Your
The
Lordship,
thing is the present.
appeal was served by somehow.
I have received.
No, he has received it.
Madam,
Today we will
but
continue.
only thing is that the appeal is not in maintainable in the present form because they have filed an appeal by the ITO, income tax officer. As per section 260, subsection 2, the principal commissioner has to file an appeal.
Your Lordship, this was named in the name of Principal Commissioner, but Principal Commissioner of Patna is the person who is filing this petition. So objection was raised by the department. I have copy of scanned copies of those documents affirmed as well. They raised that Patna, a person cannot file it over here because the jurisdiction lies in Patna. But this is a transferred matter. So we had to change the cause title and file it in the name of income tax officer, because I cannot write Kolkata when I am signing in name of Patna. A person from Bihar would be signing for Kolkata, that would be wrong.
Right.
So I advised my client that it cannot be done for Kolkata, you cannot sign. Because you are representing Patna, you have a representation.
Now then, can you implead the Patna commissioner as a pro forma respondent?
Yes, ma'am.
That you do it.
Your
Next.
Lordship.
We have heard the learned standing counsel for the appellant and Mr. Avram Mazmundar, learned counsel appearing for the respondent assistance. There is a delay of 38 days in filing the appeal. We are satisfied with the explanation offered, and the delay in filing the appeal is condoned. Application allowed. Since this appeal was initially filed before the High Court at Patna.
Your Lordship, by the, not at High Court, Your Lordship, by the department in, Income Tax Department in.
This appeal arises out of an assessment which is within the jurisdiction of the where do you get this Patna? No, this appeal arises out of a matter concerning an assessee who is at Patna. Therefore, this appeal has been filed by the income tax officer through the Assistant Commissioner of Income Tax through the Assistant Commissioner of Income Tax, Commissioner Circle 1 Patna. And it says, and Kolkata Income Tax Patna and the Kolkata Income Tax Department. The learned advocate appearing for the respondent assessee submits that the appeal in such form is not maintainable. However, considering the fact that the assessee is in Patna, this appeal has been filed in the present form and the same is accepted and the accepted. Let the appeal be listed for admission on the next date.
Lordship, regarding the delay, Your Lordship, the inconvenience faced by us is that in Supreme Court, Your Lordship, when we file a petition, 90 days time is given for clearing the defects. Over here, we don't have a system of clearing of defects, any time given to us, and that limitation stops as soon as we file it. But in Calcutta High Court, when we are filing online, Your Lordship, in all cases, we are facing this difficulty. Either the portal is not working for 15 days, like for right now, we are not able to upload anything. We are giving it in E-Seva Kendra. But the limitation doesn't stop, Your Lordship. It is running. In this present case, this was filed within time, but the defects were raised after that, so there is a limitation.
But for curing the defects, are you not?
You know, we are not having any time limit. We should be given that at least 15 days, 30 days.
Reasonable time is.
The report is being given by the department calculating the delay.
Your Lordship, in the present case, my limitation stopped on 16th. I filed it on 15th. I obtained a report on 16th. There is no delay. The defect was raised on 18th.
But immediately when you file the appeal, the limitation stops.
Lordship, that's what, when I'm filing online, it should stop, but it is not stopping over here because they are asking after the defects, after it is e-filed, they'll raise the defects. After the defects are made, we need to file the physical copy after clearing the defects. But as soon as I file it online, my limitation should stop. It is not stopping in the present cases in Calcutta.
Okay, we'll do so. Next.
Item number 5.
May I please, Your Lordship? This matter is first time appearing. I've served. There is a delay.
Covered issues or no?
No, tribunal has followed the judgment of the Honorable Gujarat High Court. I found out in the research that the SLB was rejected. That's the most that I can say.
But SLB rejected on delay ground.
No, on merits.
Because
Today we will condone the delay.
Yes, madam.
Sir, please come. We have heard so and so. That first paragraph of the previous delay. Satisfied so and so. Carefully you put it.
Item number 6.
Affidavit of service. Same order.
But I am filing affidavit of service, madam. Item number 7.
But I'm appearing, not there's below 47 days, not we have
49 days.
49, sorry.
Delay condoned.
Item number 8.
Not 8, not I'm appearing, not to serve, my lord.
69 days delay condoned.
So you come back.
Item number 10.
8, 9, 9, 9.
9.
8
and 9.
8 and 9.
8 and 9 delay condoned.
I'm grateful.
Item
Who
number
is
10.
appearing, you please give your appearance. Item
143
10.
days delay, my lord. 10.
But if it may only be recorded that I'm vehemently objecting to my.
Yes. Condoned. Next.
Item number 11.
107 days, my lord.
107 days condoned.
My lord,
Already the service was.
my lord, here regarding service, the envelope has returned. But I have also sent an email, my lord.
Affidavit of service has been filed.
No,
Affidavit-
before I have incorporated my email in the affidavit of service.
Has it been served?
My lord, email.
No, the cover has
First it
returned.
was served.
What has returned?
It has returned back with a postal ring.
What is the endorsement, postal endorsement? Left or incorrect address?
Left.
Left.
When have you served through email?
Email cover.
Just a moment, my lord. It was on 2nd of April.
It has been annexed to the affidavit of service. my
11.
lord. The screenshot has been annexed.
We have heard so and so. There is a delay of 107 days in filing the appeal. The notice which was sent through speed post has returned with the endorsement left, inverted comma. The learned advocate for the appellant has sent an email to the assessee on 4th of April 2024.
On 2nd of April.
2nd of
Of
April.
April 2024, and a screenshot of the same has been filed. Hence, it is deemed that service of notice on the respondent is completed. Full stop. As we are satisfied with the explanation offered for not preferring the appeal within the period of limitation, the delay in filing the appeal is condoned. Application allowed. Next.
Item number 12.
1451.
1415.
We have heard Mr. Soman Bhattacharjee, learned senior standing counsel for the appellant revenue. There is a delay of 1451 days in filing the appeal. We have perused the affidavit filed in support of the application and we find no acceptable reason for condoning the inordinate delay. Hence, application dismissed. Consequently, the appeal stands rejected. Same order in the next matter also.
13.
1591.
159.
Same order in the next matter.
Item number
But
14.
Here it is
the case is interesting, my lord.
Same order, item 13, 14, Mr. Amit Sharma.
I am led by Mr. Rai.
Om Narayan Rai, Mr. Amit Sharma. Then next
Item
item,
number 15.
15.
Opposing this matter, appeal, my lord.
What is this?
My lord, this matter is relating to the seizure of gold, silver, and gold coin from a bullion merchant. I am a bullion merchant with having 150 crore of annual turnover of this, and the adjudicating authority held this that so far silver item is concerned, which is valued about 2.02 crore. They are all validly backed by the document, etc., and the imports are all lawful. From their appeal is preferred to the commissioner, and so far the gold is concerned, he says that the gold documents are there, but there is a export-import violation by the upholds the confiscation so far gold is concerned. When the matter goes in appeal before the commissioner appeal upholds the order of the adjudicating authority who holds, and he independently holds that so far silver is concerned, all backed by document, there is nothing that good. So far the gold is concerned, he says that I go into the supply chain, documents are there, but there is certain discrepancy in the supply chain. So he wants to pick some holes, if I use borrow your lordship's language, pick some hole, and he does that. and appeal is, both sides appeal dismissed. I go to the tribunal, and in that they don't go to the tribunal. So, my lord, so far silver part is concerned, it is absolutely clear. So for gold is concerned, the tribunal says is that there is no investigation by the tribunal, by the government, when I have given the evidence of my purchase, and when there is nothing, and the burden to prove which is under with me with under section 123, this is done by the owner system. I give my documents, etc. They examine it to be correct. It is an IGST bill, and when it is IGST bill, and there they do not find anything. They say from where you have bought means by supplier. My supplier gives the data from where he bought. Then they say you have not paid in full to that person. But this kind of really, which I can use it, my lord, that funny kind of thing. They want to distinguish in a matter where I am to make out a preponderance of probability case, and tribunal allows my appeal. From there, my lord, they have come up in High Court, my lord. From this is their appeal, and so my lord, my goods are lying since gold, silver since 2022. This is total on facts, nothing on. One cannot be expected to run till the bill of entry is filed. Well, may show that part of the adjudicating authority's order, which is at page. If my lord, we kindly
have to hear the appeal.
Yes, sir.
My lord, the appeal needs to be heard, lordship. Let it be admitted, lordship.
But you shouldn't sell the gold.
No, my lord, we shall. Your lordship kindly puts us to term. We'll put it. We will wait to your lordship's terms, and we'll keep the matter pending. Lordship can kindly hear out the appeal.
Releasing the goods. My goods may be released to me, and my lord, to kindly see page 167.
Yeah, to hear the arguments for release of goods, as to hear the appeal is one and the same.
Yes, my lord.
But today we can't hear the appeal.
My lord, my
because
lord.
Admissions has to proceed.
Yes, yes, my lord.
So we can give you some date.
Yes.
In May. This month is not possible.
As your lordship pleases, my lord, but may I suggest one thing, my lord? So far silver is concerned, where is there no dispute, that may be released. There is no point of argument there. So far, then gold remains of.
As far as silver is concerned, submission of Ms. Mehta is that the Commissioner Appeals rejected your appeal also. You did not prefer an appeal to the
My lord, we wanted to prefer an appeal before the learned tribunal, but that is within the statutory time for preference of the said appeal, the appeal which was preferred by them in respect of gold, it was disposed of. Thereby, my lord, making my appeal before the tribunal so far the silvers are concerned infructuous. Left my lord.
Where is the direction of the tribunal with regard to release of the goods?
Yes. Lordship kindly comes to page 191. The order of the tribunal starts at page 191, and the directions are at page 232.
The internal page number?
Internal page number.
42. What has happened before the learned tribunal is, lordship, the learned.
Here silver will not be subject matter.
My lord, I can give gold bond, and my gold should be, because it is I am in business, trade in stock in trade. Do the business, gold bond values is 4 crore. So I will give them 4 crore worth of gold bond to them and let them release. By keeping gold, they won't gain anything.
Or we can do one thing.
Yes.
You file an CAN application.
My lord.
Seeking for release.
My lord, my lord.
Interim release, subject to condition, whatever it is.
My lord,
now, is there a finding rendered by the commissioner that the gold which was seized has foreign marking?
No, my lord, no. He says adjudicating.
The reason is it was melted. It was melted and cut into small pieces.
No. Adjudicating authority is deciding authority. I may read only 4 lines from page 167, volume 2. My lord, if my lord kindly see paragraph 6.3. 6.3, so far imposition is penalty. My lord has got that. And I am reading from 6th line. My lord, I further find that all these GST sale invoices. My lord got that. It is 1, 2, 3, 4, 5, 6 line. I further find that. My lord, I got that.
6 lines from the bottom.
So last paragraph. I further find that.
I further find that.
I further GST sales invoices document with specific numbers and dates are raised prior to seizure of the claimed gold without foreign inscription marking in question, and there is no contrary evidence to prove that those are generated afterwards to cover the claimed goods. I find that the transactions of money currency of more than 50,000 require PAN card. And I even find that even MMTC, who is authorized by RBI to import gold, is not making available the bill of entry to the purchaser of the gold. They are issuing the tax invoices to the purchaser. Further, for gold, there may be lot of purchaser from MMTC and it will be very difficult to make available import documents like bill of entry and every purchaser. Therefore, asking the import's bill of entry to prove legitimate import is quite harsh. Anurag Jalan has discharged his burden of proof by submitting those documents, but as against the gold bars are restricted. Subject to RBI regulation, no compliance has been made by Anurag Jalan, which is the violation of import policy read with Customs Act, and therefore goods are liable for confiscation, etc. And this was not a matter and for import. I was not the importer. He goes extraneous. Charge was smuggling. And that the goods are not foreign marking, they are alloy. They are indigenous goods.
Also, kindly appreciate that searches were made at 3 places.
Yes.
Searches were made at 3 places, one at a sari showroom, one at a residential place, and one at the bullion office of the respondent. Also, 10 kgs of golds were seized. 6 kgs from one places and 4 kgs from the other places. If the gold were not smuggled gold, they would have kept it at their own office premises or at their own showroom. There was no need to keep those gold of 6 kg at a sari showroom and 4 kg gold at a residential premises of his employee. And there are statements made by the concerned persons who have clearly said that he was in this kind of transactions in earlier occasions also. And no licit documents could be produced. He was summoned, he was asked to produce licit documents in support of his gold transactions or gold business, but he could not produce any such documents.
That study shop is my own.
No, so far at page 168, in paragraph 64B,
yes, my lord.
He says, I do not give an order for absolute confiscation of silver granules.
Yes, my lord, yes.
So therefore, silver granules, there is no bar, it can be returned.
Yes,
For a concern, even the adjudicating authority has released the silver. Or the golds were confiscated along with the money.
What I'm submitting is silver may be released, no quarrel on silver. So for
if you want to file an application
my lord,
for a relief, because it's a case of absolute confiscation. So therefore, to order for release of it, whether it can be a conditional release subject to value of the gold being
yes. But the my lord may agree for this because so I'm giving him gold bond, he will earn interest on that. And here gold will not ultimately is to return back to me. No evidence, nothing of the kind. And my lord,
all right, we will consider that application for release separately. The appeal is admitted.
No, appeal, my lord, may not admit it, my lord, keep it like this as it. And my lord knows, my lord, the style of things is excellent. When my lord admits, disposes of the appeal, let it be like that, my lord. Let it be like that. All papers are here. There is nothing outside. My lord, this will unnecessarily linger the matter and so.
It has to
My lord, can keep it the matter as the same stays.
All right, we have heard Mr. Kaushik De, Mr. Sudhir Mehta, etc. The learned advocates pray for an early date for hearing of the appeal at the admission stage. The learned advocate appearing for the respondent assessee submits that the confiscated gold may be directed to be returned, and the the assessee is ready and willing to secure the interest of revenue. If such a to consider such a prayer, we grant liberty to the respondent to file an appropriate application in this appeal. Next para. As could be seen from the order of adjudication dated
(23/5/2022).
23/5/2022.
At page 41.
Passed by the Additional Commissioner of Customs within bracket preventive, Kolkata. So far as the silver granules which were confiscated, the same has been directed to be released to the rightful owners. Therefore, the appellant department is directed to release the silver granules to the rightful owners, since
Silver articles, granule and coins, both all released.
it says silver granule.
In the prayer, my lord, the adjudicating authority deals with granules and silver coin also, my lord. So he discharges both.
Silver granules mixed with white colored coins and 20 pieces of gold guineas.
And gold coins.
That is 20 pieces.
Yeah, yes, ma'am.
As mentioned in paragraph 64 within bracket B of the order passed by the adjudicating authority to the rightful owners on an application being made by the said owners to the respondent. This direction is issued since the appeal filed by the department against this direction of the adjudicating authority was dismissed, and as against the same, the department did not prefer any appeal to the effect. And therefore, the direction issued by the adjudicating authority in paragraph 16 within bracket B of the order stands confirmed as on date. The above direction we complied with within a period of 10 days from the date on which the application is filed for return by the rightful owners. Let the matter come up under the same caption on 17th May.
17th
May. Meantime, you serve the application so that if you want, they can file a.
Yes, sure. One well understood, one two line which is in Urdu, my lord. चिराग बुझ गया, तेल नहीं था. सब blame हवाओं को. Entire thing this or this, the lamp exhausted because there was no oil, but the blame is on the moist air. That is what.
Next.
Item number 16 and 17.
My lord have come up with a very innocuous prayer, my lord. This is a recalling of your lordship's order dated 26th of April 2023, page 24, my lord. The issue before your lordship was with regard to that addition, whether the addition can be made under section 153C, where no incriminating materials found. Now, in this matter, your lordship, the assessment years pertains, কত ছিল 2000?
No, what
From
happened to the notice?
2003-4 to 2008-9.
Have you served notice on
Yes. Yes, on the last occasion also, because when the delay was condoned, my lord, we have submitted that we have already, and this is the second time service was also made. Email. It was
on
also.
whom? Last order was on 23rd February. It says, advocate for the department is permitted to serve the learned counsel on record for the assessee who appeared in both cases. In addition, service through email. Who appeared in both cases?
Mr. Khaitan appeared in that matter, and the advocate on record was Mrs. Shopna Dash. But now he has I think so. She is no longer appearing. She's not holding the brief.
No longer.
Certainty.
Very short.
Now, first we have to condone the delay.
No, delay has been condoned.
No.
Delay condoned.
On what date it was condoned? GA3 is still pending, not condoned. Smita. We have heard Smita Daste, Pruthi Dorial, and standing also for the respondent. In terms of the directions issued in the order dated 23rd February 2024, notice has been served on the assessee as well as on the erstwhile on the counsels who appeared.
Affidavit service is not ready, my lord. Affidavit service is not ready, my lord. 10th only.
All right, matter adjourned by 2 weeks for filing
May I
affidavit
seek
of
only
service.
one indulgence, 23rd of February 2024, his name is not featured.
Next time you will. Next,
Item number 18.
It's a contempt application.
item 18.
Matlab, this is matlab, an appeal. Matlab,
Appeal application.
matlab, there are matlab, one thing matlab, before matlab, by learned friend matlab, starts matlab, the matter. Matlab, the person concerned, matlab, this is in respect of matlab, the ISWBM society where your lordship had matlab, was matlab, pleased to already pass an order matlab, keeping status quo matlab, with regard to matlab, the position of the society as on matlab, on before 30th of May matlab, 2017. Now, matlab, that was continuing matlab, in matlab, they have though matlab, filed an application for contempt of that order matlab, that is still pending matlab. Now matlab, they have filed matlab, one more application matlab, matlab, asking matlab, that the respondent should be allowed to matlab, participate as a treasurer of the society. Matlab, a prayer matlab, which in my respectful submission perhaps will be matlab, beyond the scope of the appeal that I have filed. Matlab. I'm really
Now,
for
what
the
has
appeal.
to be done today?
No, my lord,
Matlab, I'll tell you lordship.
kindly
matlab,
come to my application.
just only one thing matlab,
By this affidavit, crores of rupees has been siphoned out, which you was apprehending of. If you lordship kindly recall, your lordship kindly see your lordship's order. No, no, order.
Matlab, the person concerned matlab, who was there in charge of the society matlab,
Page 28.
Kindly come to page
28.
একটা জিনিস বলে রাখছি
kindly come to page 20.
যে লোকটা ছিল না দীপঙ্কর দাশগুপ্ত
No, no, we'll hear the appeal. Why is all these applications after application?
I have no problem with that, but in the meantime, my lord, what do you apprehensive of? Why the honorable single judge has, my lord, restored back the position? Normally, court does not do it. It has restored back the position which the original order resolution was passed. It's an unusual order. Passed on the basis of a fact that somebody who was the helm of the affairs is now behind the bar, the minister. Now, my lord, entire resolution has been changed, altered just to oust him and kept it in his own hand. On that ground, my lord, this single judge has.
This is a society, is it?
Yes. But can
That is also a question, my lord, whether it will come under an Article 12 authority
come to page 20.
or amenable to writ jurisdiction. These points your lordship will consider at the time of hearing of the appeal. It's a privately managed society, internal affairs of a privately managed society, whether amenable to writ jurisdiction. That
has been decided.
Why was the Department of School Education implemented as a respondent?
Yes.
They are the 10th respondent in the appeal.
10th respondent.
And what is their role in the matter?
They are one of the governing body members by virtue
Oh,
of
by
office.
virtue of the, my lord, office, he is the member of the society.
Yes.
That's what, my lord, see your lordship's order. Everything, I think your lordship come to your lordship's mind. Page 28 is the order in the application. Order dated 27 September 2023.
One application to
G3.
G3.
Oh, Nampa Jaina. Last
ডিরেক্টর অ্যাপয়েন্ট করে দিয়েছে উইদাউট ইনফর্মিং আস ডিরেক্টর চেঞ্জ হয়ে গেছে অ্যাক্টিং হয়ে গেছে
I was the treasurer, তাই তো?
হ্যাঁ
না treasurer ছিলাম তো, তাই তো?
লিগাল ট্রেজারার ফ্রম 81 আর এই ডক্টর দীপঙ্কর দাশগুপ্ত অসুস্থ বলে আরেকজনকে অ্যাপয়েন্ট করে দিয়েছে উইদাউট ইনফর্মিং মি
সেই তো আপনার
আমার কিছু করার নেই, আমার কি
মরে গেলে আমি কি করবো?
না না তার আগে অসুস্থ ছিল
কাউকে ডাক করছে আমি ধরছি গভর্নিং বডি একটি করছে আমার মানে কোর্টে অর্ডার আছে যে আমাকে
You have not argued that the writ was not maintainable. There is nothing.
In the court below it was taken, court had affirmed that.
In which paragraph the court says it is maintainable?
Just a minute, my lord, I am showing to you. Court below it was argued.
Impugned order.
Well, paragraph 6 and 7 of the impugned judgment, you also can take hints of that.
That's something.
But there is no findings, sir.
There is no findings there. The manner it was asked, that was the finding.
Subject to correction, that issue your lordship can also take note of in the appeal.
You raised that point. We are perusing.
Yes,
that has not been decided, not raised. At least you should have raised that as a preliminary objection.
Not properly raised that.
That manner it has not been placed, but is trying to say that except upon a BOT, state has no role to control. This is the submission, paragraph 7.
But the submission Mr. Sen was making today is
that specific submission was not there.
That is not.
I accept it, Milord. I say that to that extent there is no submission which was made. But only one thing, Milord, I must point out, Milord. The person
Was in charge of the day-to-day management of.
In the
person
meantime,
who had
appoint
given
somebody
us
from
the
the court.
Just one second.
You will hear the affairs of the affairs.
The person.
Otherwise, my lord, the main object of it will be penniless within a short period of time.
But these are allegations, my lord. Today, my lord, the person who was dealing in the matter, my lord, he has passed away. So, my lord, I do not have a proper wakalatnama as of today. Because we were being represented by my Mr. Dipankar Dasgupta, who
And
was
somebody will be appointed without
director,
consulting me, as I am the treasurer.
Who was the director and member secretary.
No, the appellant is the director and member secretary.
Yes,
Board of
the concerned person had passed away.
Now somebody has to be appointed.
Yes.
But in the appointment, I'm sure I will not be consulted. They are doing this only.
But that is.
I am only one of the outsider, so I should be taken out of the society so that they can do at their own choice.
Let us not. Prejudice is all good.
This is all finding of the court.
All prejudice
Of
is all
the
good.
single judge.
Here, your lordship is going to inter.
Who affirmed the affidavit or this appeal memorandum?
Dipankar Dasgupta.
An office memorandum, somebody has been appointed.
And he is no more.
He is no.
He passed away on 3rd of April.
3rd of April, this month.
Page 36A.
Well, I would.
Secondly, 36A. March. He was hospitalized.
Lordship, if there is a short time, by that time I shall file a wakalatnama and a short affidavit to GA number 3. Your lordship can hear out the appeal. My submission.
36A.
The gentleman was in hospital, was hospitalized. At that point of time, somebody else has been appointed that your lordship will get at 36A. Let them show to your lordship that I have been consulted. I am the treasurer of the society. Your lordship has put me in that position. They appointed somebody as an interim measure. Page 36A.
But treasurer of the board of trustees.
Trustee will not be called now. Whatever I am.
Very well, let us go in, but we shall satisfy your lordship on the basis of the rules and the memorandum. To what extent the treasurer will be required to be consulted?
The maintainability point to decide. Very clearly, he has first decided that and then he has done.
I have no problem.
This is a new application which has been filed in the appeal.
I have compelled.
This application can be heard out along with the appeal.
But then
Allow me to participate as a treasurer.
No, allow me to participate.
And I do not, no, subject to correction, no, kindly have a look at the first prayer. Allow the present applicant writ petitioner to function as a treasurer.
That is your lordship's order.
No. When we heard the matter, we passed an order on 27 September.
Yes,
where we observed that the board of trustees could not have taken a decision to state that the board has been scrapped. How you can take such a decision we have made?
Yes.
Yes.
And we have said in our privacy view is a decision taken without jurisdiction.
Yes, your lordship has said.
One.
And then your lordship has said that it must
status quo ante on that date should be maintained. So there I was there. And if your lordship read the order of the honorable single judge, my lord will find the corruption is the main ground.
No, my lord, that should not. Well, I shall use a short affidavit to this application.
No, we have already rejected the prayer for grant of interport. On 27 September 23, we said, and it does not arise, and whatever was the situation which was prevailing prior to the impugned resolution of the Board of Governors dated May 30th, 2017, shall be maintained till the appeal is heard and disposed of.
Yes.
So you restore that position.
It is there. But that position is being maintained.
I had a room. I have not been allowed a
That
room.
position
I am not
is being
allowed to
maintained.
enter into the room of
But
office. Nothing.
Here his trade is something else.
We are not in GA3 or GA1 or
Yes.
GA2. You first obey this order and come. If you do not obey this order, you will not be heard in the matter.
Very well.
Well,
I shall
appoint
file a
somebody.
report. I shall
I
file a
request your
report.
lordship, is a prestigious institute. The specific finding of the honorable single judge, it has to be preserved. Kindly appoint somebody who will look after the affair till
Not today, my lord. Kindly
my
see,
lord is
not
hearing the
kindly.
appeal.
Let me bring to your lordship.
Now the director is no more.
Yes.
Who will manage the affair?
But there is an officer, my lord, who has already been appointed when he was in the hospital. The director was in the hospital.
What is the cadre of the officer?
But kindly see.
Member of the Board of Governors.
He is document.
He can't discharge the powers of the Board of Governors.
No.
Then what?
He is just an authorized representative.
Of whom?
Of the Board of Governors.
How he can be?
But someone has to act, my lord.
Appoint somebody.
It is
Someone
like
has
a
to
managing
appoint
director.
somebody.
No. That is why. What was he? Please show the composition prior to 35/2017.
Yes.
It is status quo ante to be restored. That order is there. This order has become final. You better comply with this order.
Very well, your lordship will give me next week. I will file a compliance report. What was the position as on 30th May 2017 and whether that position is prevailing
Mr.
today.
Kishore Dattu appeared on that day. You heard elaborate submissions and we have made it clear that status quo ante should be restored.
Yes, I maintain that, my lord. I am maintaining that position.
Document says he is not maintaining this.
I will justify that, my lord. I have filed an affidavit.
He can't even initiate contempt. The person is no more.
I am not on contempt for execution. Read, my lord, the contempt, there is no execution proceeding. The read is also an execution proceeding.
We have heard so and so. Several applications have been filed. 3 applications have been filed by the respondent. Before we consider the prayer sought for in those applications, we direct the appellant to comply with the order dated 27 September 2023 by restoring the position which was prevailing prior to the impugned resolution of the Board of Governors dated May 30, 2017. In other words, status quo which was prevailing prior to the said date should be maintained scrupulously. It is submitted that the director of the appellant who had filed the appeal is no more, and an appropriate application will be brought about for substitution. Leave to do so.
What is the in the meantime, can peruse this.
In the event the appellant do not comply with the order dated 27th September 2023 in its letter and spirit,
It was taken and decided.
court may be constrained to
It was taken and
appoint an administrator for the institution. List the matter on so and so date.
But the point of mental was taken up separately and decided separately.
That was decided first.
That was decided first, thereafter main matter. It was not mine matters. I'm sorry.
This order is with the next to the contempt application. Put it out.
আমরা একটা অ্যাফিডেভিট ফাইল করে ওটা বলে দাও না। আমরা কি অ্যাফিডেভিট ফাইল করবো?
আইটেম 70 টা কন্টেম্পটা আছে ওটা কি এখন করে নেবেন?
হ্যাঁ
আইটেম 70 আছে কন্টেম্পটা ওটা বলে দিন না কন্টেম্পটা তো হবে না কন্টেম্পটা এখন
কন্টেম্পটাকে ইনফ্রাকচুয়াস কন্টেম্পটা তো ইনফ্রাকচুয়াস মরে গেছে পড়া কিছু নেই ইনফ্রাকচুয়াস করিয়ে দিই ওটা
একটু ভালো করে বসতে হবে
ব্যাংক ফ্যাংক অনেক আছে তো আরে কন্টেম্প তো হবে
Yes, we give a date. Next.
Item number 70 is the related contempt application. Lordship can, person has already expired, remain contemner.
No, there are more than one contemner.
contempt number 1 has
কতজন আছে
Sir,
কতজন
can you get to item 75?
oh no cannot be disposed of
It can't.
but maybe other banks officials are also there
No, no, 70 you can take.
come on মরে গেছে সব রাখতে পারে না সেটাই কাম প্র্যাকটিস বার করনা আছে রোজে বার করতে কে কে আছে
তিনটে ব্যাংক আছে
কাগজ
Bank
বেশি হয়ে
of
গেছে
Bank officials, my lord, the other contempt.
one may be expunged due to death but others are there
No, there are two.
yes bank officers are there they are acting is contrary to your lordship's order
No, no, you please take the cause title in the contempt application.
yes one expunged
That is Dipendra Kumar Sanya.
one no Dipankar Dasgupta
Page 7.
page 7 Dipankar Dasgupta
one has died
Dipankar Dasgupta.
died
He has passed away.
rest my lord they are
they're like
Bank
Like-
officials.
Why you are penalizing the bank officials?
no reason is there my lord said Terrasco ante on that date who was the signatories my name was there they are refused
No.
to-
No,
Oh,
that,
yes or
that
no,
we
this
have,
is our case
we have already filed an affidavit.
This is
His
our
name was
case.
not there.
This is our case.
It was your case, we had a different case.
Maybe that's why. তুই পয়সা পিছিয়ে দুটো বলছিস আমি পয়সা পিছিয়ে দুটো বলছি এই তো
So whoever was discharging the duties as a director on behalf of the director, when he was hospitalized,
36 page 36A
he should be included as a contempt.
Very well. We shall give the name and particulars.
he has the name ওই 36 এতে যেটা আছে কেম আগরওয়াল নাকি না আগরওয়াল
KM Agarwal.
আগরওয়াল হ্যাঁ
দেখিছো
Where do you get his name?
Well, that is
page
a,
36A of the application filed by us
A3 application in the
Yeah.
appeal
A3 টা একটা দাও
But who appointed him as director?
That
acting?
our question
the board of governors. The board of governors exists.
there's a two
And the board of governors is the actual administrative body.
supervising
contempt application.
Board of trustees is not the administrative body. Well, not every
Right, who as on date, apart from Mr. Dipankar Das Gupta, who are the other board of governors?
members of the board of governors. Well, I shall file the list before your lordship.
Please show it from this document.
this is not there they have not annexed the entire document
Well, the entire list is not. This is their application.
No. But how can he be? He can be made as a probably a secretary or something. How can he be termed as director acting?
because at the time he did not die he was hospitalized
I think it is better this institution is superseded. The board is superseded.
Well, very well. Let me bring it before your lordship. My lord, what is the position? Your lordship keeps it next.
These fellows think they have become owners of the.
yes
They become
that is the finding of a single judge
It has gone into their head. So it's high time we strip them of their position and we supersede the board.
Your lordship will give me 1 week time. Let me present before your lordship what is
Then
the
don't operate the bank account.
Yes.
Don't
Correct.
operate
For the
the
time
bank.
being.
Yes.
No, kindly, but
Except
today,
salary. Salary, my lord, I will not oppose.
Wait, sir.
Sorry.
There is allegation, of course, you will get an opportunity to deny. But your action should be above board.
absolutely. Yes, Lord. But kindly give me 1 week time to clear all your lordship's doubts.
Why do you fight among yourselves and kill the institution?
That is
That's
very unfortunate, Lord. Extremely unfortunate.
Show us from any of the document who are the other board members. Who are the other board members? We'll issue notice of contempt to all of them. Let all of them appear before you, however high they may be. Let them appear. That's better.
Well, kindly keep it on Monday.
Right and now, you please tell. We issue notice of contempt, and all of them are here at 10:30 a.m. on Monday. We will not fix a time for the matter. We will take up. Let them see what High Court is. Let them.
No, kindly give me an opportunity to present before your lordship, my lord, what is the
Fight of the interim order, Mr. Stanley. This is not expected.
My lord, my lord, I shall show your lordship. I have filed an affidavit in the contempt. I shall show your lordship from the affidavit in the contempt that we have not altered the status quo. That status of 31st May 2017, we have not altered. Let my learned friend show your lordship.
Suppose if it is not altered, who has been operating the bank account? This director acting. Under what rule or what, bylaw or?
Yes, under the bylaws, my lord, the Board of Governors is the administrative body. My learned friend is not a member of the Board of Governors. He is saying that he is from the Board of Trustees. Two are two different authorities.
But then you are so autocratic.
No.
Dissolve the trustee.
I kindly give me one opportunity to satisfy your lordship on merits. One opportunity.
You please, or we will summon this director.
Well, your lordship will kindly come to your lordship's order of 20th December once. First in the contempt matter.
20th December.
Mislead করেছে তারপরে ওরা সাপ্লিমেন্টারি অ্যাফিডেভিট করে ওটাকে কারেকশন করেছে
prior to
কি আছে সেটা
কারেকশন কি বলছি না যেদিন করেছিল দেখালো দুটো আছে আপনার কোর্টকে মিসলিড করেছে তারপর নিজে দেখেছিলাম না যে সাপ্লিমেন্টারি অ্যাফিডেভিট করে ওটাকে রেকটিফাই করেছে হাউ দে আর মিসলিডিং দ্য কোর্ট
Well, your lordship has not.
দেখাতে দাও দেখা
Sir, the bank was also a party to the order. Then how did you permit this K.M. Agarwal to operate the account? Yes.
Well, your lordship has noted it in your lordship's order of 20th of December.
Clause number 73 of the Board of Governors will have power.
তখন বলেছিল না দুজনই আছে ওখানে হোটেলে বলেছে তারপরে ওখানে আমাদের এখানে বলছে বোর্ড অফ গভর্নমেন্ট মিটিং হেল্ড হচ্ছে না আসুক না তারপরে ওরা তখন নিজে বলছে in terms of the resolution name of Amitabh Jata among 5 authorized authorities were nominated for a court case. They were only nominated. They were only authorized. And the said nominee signed on the specimen signature.
Correct, sir. Prior to 2017, there should have been a mandate given to the board. I'm blank.
It is there.
The board of trustees decides in which bank the account has to be opened. Board of trustees decides. The board of governors will be entitled to authorize who will operate the bank account. Prior to 2017, there is an authorization or a mandate given to the bank. You have to follow that mandate.
That is being done.
No.
That is being done. Your lordship will kindly come to your lordship's order once, my lord.
20th December.
Let the bank answer, sir.
Very well.
Why are
They
we
have
going
the
by the
card.
order?
They have the card with them.
What is the position?
Yes.
Exactly what is the position?
All right. If the back date, Mr. Agarwal could not have signed the check.
Board of Governors.
That mandate is there, sir, prior to 2017. Members have authorized 1, 2 or 3 people. Only those 3 can operate.
That is the order.
My lord, the Board of Governors has the
No, I think you and the bank are trying to frustrate the order. We will summon this director. Agarwal, let him be present.
But only one opportunity, your lordship.
He's a very big man, is it?
No. I am not trying to defend any of them. I am only saying this, my lord. The lordship has.
You please produce the resolution
Very well.
by which this man was appointed as director acting.
Yes.
And you produce the entire bylaws or whatever rules and regulations.
That is part of my appeal. The entire bylaws and that is part of the
That has
appeal.
been considered by the single. Well, I have a 2013 mandate.
The last mandate.
This is, my lord, the mandate to the bank.
I have this is part of my affidavit in opposition.
Then why you're saying I'm
Here,
not
my name is there.
one of the signatories?
It is considered kori to এই order
Yes, this mandate you have to adopt. That's all.
No.
9th October 2013, my lord, there is a written instruction
Yes, that is the one.
given by
page
the
before
director of the Institute to Manage State Bank of India,
5
Again,
persons
Abhijit.
were appointed
in
out of which
which
3.
resolution of the board has been referred to. Resolution reads board resolve
Yes, that is the one.
9th October 2013.
13. There are 5 persons, my lord, Dr.
Yes,
Suranjan Das,
Yes.
Amitava Sarkar, Dipendra Kumar Sannal,
I'm-
Praveer Chakraborty, Shantanu Bhattacharjee. 5 persons.
My name figures there.
And kindly see, in terms of the above resolution, your lordship will record 5 persons partners were authorized signatories of checks for banking operation. And resolution says that the existing arrangement of signature by any two
No.
of these 5, any two can operate.
So
So that any two is continuing.
the only alive
Canara
one.
Bank
I'm
and
only
State
alive
Bank.
one.
We have given the mandate.
Yes.
Who will sign?
Yes.
My lord,
Canara Bank and State Bank.
Yes.
this is the
That is what is
mandate
there.
given to
There is
the
their own application. Yes. Apart from Sanyal, all other persons have either resigned or died.
His name does not appear.
Your lordship has recorded it. There is a list of various signatories who have signed in the annexure to the communication. There is a mandate form which has been signed by the president and the director,
Because they were the new added.
Dr. Suranjan Das and Amitava Sarkar, and the signature of the applicant is not found in the mandate.
The fight.
But this Dipendra Kumar Sanyal is
Not there.
signature is not there in the
Not
mandate.
there.
He was early.
Exactly.
He was since
That is
there
what
since
is
very
lordship
early.
recorded here in
These
the
two
order.
were the added
I'll
one.
see the date.
Yes.
He's been there
Prior to-
since very
prior to
prior
30th May
87.
Prior to 2017.
He's been there since 87. Only the new added one were added. That additional essentially bolo. Well, then it is reflecting in their own affidavit. You forgot.
Say to the page.
Or he's saying his name is not following. His name is not there because the earlier being there since 88. It is there. They were there till 88.
How will that
And 87, this like 2013, only the
But
new two
normally-
were replaced.
When you are given authorization, this existing arrangement of signatures by any two will continue.
Yes.
Which are the any two? You
From
should
the
have
five
taken
members.
it.
That is given in the mandate form, which is
the
given to
files.
the mandate, which is given to the bank. The mandate form contains the signature of any two of those 5.
Signed or died.
That has been recorded by your lordship.
From that mandate, sorry.
It's my operation. And since 1988, I'm operating this.
Any two.
Since resolution and circulation.
Because they will not allow-
My mandate with the bank is since 1981. So that is why my mandate was continuing. My mandate. Out of
Any two.
what shall I learn?
Any two.
They're not specific. So all 5 should have-
যেখানে নতুন সিগনেটারি কোনো ব্যাংকের লোক প্রেজেন্ট ছিল না, শুনবে না।
See, mine is still, I am here till 81. It I'm a bank resolution. A bank. So I am continuing since 81. যখন দুটো addition হয় কেউ director ফিরেক্টর add হয় তাদের নাম additionally there. ওইটাই আছে. That is there. I am there since 81. I'm the signatory. I'm signing the checks. And out of those five, out of those five, the erstwhile director had reported the major affidavit balance. I am the only alive signatory out of the five today. That's what I'm saying.
Since 1981, I am there.
I'm the signatory
And
since
I
91.
just now I've handed over.
The resolution is sort of misleading. It says the board resolved that this president so and so, five people will be the authorized signatories, authorized signatories of check for banking operation. That means the mandate should contain five signatures.
Five. Those are there.
The next one. The existing arrangement of signatures by any two will continue.
Out of the
So, when you give the mandate to the bank, you should give five signatures, out of which if any two of them sign, the bank will honor. But the mandate has been given only for two.
No. Mandate is for five. Next page is.
Kindly see the names. Kindly read the names. I will show to you also who is alive.
My signature is there.
Suranjan Das.
Suranjan Das.
Gone.
He's the president of Board of Governors.
He's not there. Then
Amitava Sarkar.
Because this was of 2013.
Wait.
This is 2013.
Dipender Kumar Sanyal.
Me.
Prabir Chakravarti.
Gone.
Shantanu Bhattacharya.
No more. So only I was the existing signatory. So if your lordship is directed to lead it back to this position, then I will be must be one of the signatory.
You yourself and Amitava Sarkar.
No,
was also got
he is not there. He retired. He is no more in the organization.
So you will be the sole.
As it appears.
At that time he was there.
And now what they are doing, excluding me, they are functioning.
And who is signing?
Other people handed over to my lord.
They kept on changing the resolution anytime.
On their own, they are changing resolution.
No, out of these five people, according to you, only your client is.
That is my lord satisfied. He is allowing now the mandate given by the board at that point of time.
Mandate lapses.
Thereafter, they changes the mandate. Now your lord is directed to revise back. These changes are according to the court is bad.
No. This change took place when?
After
2013.
30th.
There is no date given.
Resolution.
That has to be, the date has to be there.
Resolution.
In terms of this resolution, 27 March 2024 resolution, সেখানে ব্যাংকের লোক উপস্থিত ছিল. The bank was present. I distinctly remember the resolution.
I am not there.
That's why my lord is appears there are my lord some problem somewhere.
So the difficulty will come. As per the resolution, there will be two. As of now, there is only one.
Upon somebody, my lord, I have no problem, but institution has to run, he has to be saved. But how it can be done that I will be excluded from all arena? Entire arena of the board I have been excluded.
Board of trustees, which is
My room has been occupied by somebody else. I am not allowed to enter my room.
trustees,
And my lord, the no accounts given and the reply given that there is no room for you. You come and sit along with others. I am the treasurer.
But I have answered these points in my affidavit to his contempt petition.
I said that. This is the answer.
No, not this is the answer. My learned friend is talking about room. The entire board of trustees have become defunct.
After we have elaborately heard the learned advocates for the parties, we are of the prime facie view that the persons who are in the helm of affairs of the institution are trying to circumvent the earlier interim orders granted by this court. However, as of now, we do not wish to express any opinion, but give an opportunity to the appellant to place before this court under what circumstances one Mr. Agarwal was appointed as director within bracket acting. The relevant Mr. K.M. Agarwal, director within bracket acting, um, who has also issued an office memorandum on 28th March 2024. That is after the interim order was passed by this court on 27th September 2023, and further order passed on 20th December 2023. Full stop. In terms of the interim order granted, the status quo which was prevailing prior to May 30th, 2017 had to be maintained. If that be so, the question would be as to who will be entitled to operate the bank account of the institute. As per the resolution dated 9th October 2013, 5 persons were authorized signatories to sign checks for banking operations. The resolution also states that the existing arrangement of signatures by any two will continue. The copy of the mandate given to the bank has authorized 2 persons, namely Dr. Dr. Amitava Sarkar and Dr. Suranjan Das. Already Amitava Sarkar and Dr. and Suranjan Das. It is submitted that as of now, both of them are not involved in the institution, and the remaining 2 persons also are not involved, and the only person who is remaining is Mr. Dipender Kumar Sanya, who was the treasurer of the institute in terms of the resolution dated 9/10/2030. Therefore, the appellant has to answer as to how the bank account could be operated excluding Mr. Dipankar Kumar Sanya. Dipendra. Here it is spelling. In this regard, the appellant is directed to place all the relevant material to enable the court to take a decision. List the contempt application along with this appeal. When do you want it, sir?
Any day, my lord. 1 week, your lordship will give me time. Huh?
Affidavit filed by the bank in the contempt application is taken on record. So today we are on 19th. 3rd May.
Copy of the bank affidavit.
After the matter is over, a precise question has been taken by Mr. Bhattacharya. Why my lord is here today?
Why he does not want the Chief Justice to be here?
No.
Yeah, single day. What I couldn't go.
Valuable right.
This time they have amended the schedule in the Representative People's Act. Postal ballot is restricted only to 9 categories. I don't come under any of the 9. So in fact, I tried for that. So working day, how to
There will be no false voting like West Bengal.
we don't know.
What are you saying?
In fact,
Truth. You are a Bengali.
Truth. Yes.
You support Bengal.
Yes, you do that. That will be the best, sir. Don't toe the line. Tomorrow, all of them will join and put you in trouble. Today, they'll be apparently fighting. Suddenly, Mr. Basu's client also joins Sen's client, and they'll put you in suit.
Matter is over, my lord. I personally want this institute should be saved. This is an old institute. If you will also read this single bench judgment, my lord will find that is the sentimental value has been put forward also.
The Chief Minister of West Bengal was.
But why such educated people are fighting?
Now the educated people.
Now there is no educated people everywhere. Your lordship won't find educated people at the helm of affairs of prestigious.
No, my lord.
The lordship
Live streaming is going on. I cannot say anything. Live streaming going on. I cannot say anything.
Leave aside this, my lord. Universities. Kindly think about our.
What lordship is suggesting, we'll appoint both of you as mediators. So that you choose.
See the cost title. do what Justice Bhattacharya wants. I should be killed.
No, you suggest the board will be reconstituted, get real good academicians.
This is the institute
With
of
that, my
eminence.
lord, I think both of us will, this is a prestigious institute. It should be safe. The problem is, my lord, finance.
No,
If finance comes in, problem.
The problem is this institute
And
is,
without finance,
it is
it cannot
not an
run.
isolated institute. This same thing is happening in every institute, which is the point of blood sorrow for the people in the state.
Without finance, institute cannot run. And the finance comes in, well, the vultures come.
Affidavit. But may we have a may we have a copy of the bank's affidavit? Bank has a copy, may we give it to us.
Next.
Item number 19.
May it please, my lord. My lord, I appeal for the respondent.
Yes,
to
sir.
assist your
Appellate,
lordship.
my lord, there is a delay of 36 days, lordship. I was humbly praying to your lordship, may the delay be condoned.
My lords, I am raising, my lords, I am appearing for the respondent. My lords, I am raising a preliminary objection. My lord, this appeal is not maintainable
Yes, sir.
under section 130E of the Act.
Ah.
My lords, and to assist your lordship, my lords, I am submitting, my lord, through my local lawyer on record, Mr. Saibal Das Gupta, a 3-judge decision, my lord, judgment of the Supreme Court, my lords, in the case of Motorola, interpreting section 130E of the Customs Act 1962. There is a specific bar, my lords, that where an exemption notification or value for the purposes of assessment is concerned, the appeal would lie directly to the Honorable Apex Court from the tribunal order, because, my lords, the uniformity of decision and all across India, the assessment should remain same. That was the intention of promulgating section 130E of the Customs Act. When it came up for their lordship's consideration, my lords, Motorola, if your lordship says, we have passed it on to assist your lordship. 3 judges of the Honorable Supreme Court, where Commissioner of Customs had filed an appeal against the tribunal order. And my lords, paragraph 9 onwards of the judgment deals specifically with this provision.
No, that is a settled position, sir.
Lordship,
If the matter concerns valuation or rate of duty, appeal directly lies to the Honorable Supreme Court. We have disposed of several appeals filed by the revenue on that ground.
And to add to what your lordship fell from your lordship, my lord, the entire scope of the appeal concerns the value for the purpose of assessment of a car, of a foreign car. The adjudicating authority, the Commissioner Appeals, the Honorable SISTAT was concerned with the notification benefit as well as value for the purposes of assessment. What would be the value?
I think the senior counsel is right, because if you see the adjudication order, page 41, I reject the value of so-and-so CIF declared in respect of vehicle, namely so-and-so, as the provisions of Rule 12 of the valuation rules 2007, read with 14.1. If it's a valuation dispute, you have to go. There's a clear bar.
And in fact, the department, my lords, appealed to the Honorable Tribunal against the Commissioner Appeals order in my favor. And page 58, if your lordship sees, their whole appeal and grounds of appeal before the tribunal also were, my lords, as far as the value is concerned. Paragraph 5 at running page 58. Fifth line from the top, if your lordship sees, from the words, therefore, the actual transaction value cannot be ascertained on the basis of any of the invoices submitted either by the dealer based in Dubai or the invoice raised in Japan. Hence, the value has to be ascertained as per the provisions of the rule of the Custom Valuation Rules 2007, which had been done on the basis of value available in the Parker's website. In the instant case, the value was redetermined on the basis of base price available on the Parker's website under Rule 9 of the Valuation Rules 2007. The prevailing price in UK of the base model LS 460, as per the information available on the Parker's website, was so-and-so pounds at the time of import in India. Price of so-and-so pounds of optional accessories, navigation system of Mark Leninson, and advanced parking guidance, which were pre-fitted in the impugned vehicle, was added in the aforesaid base value for redetermining the assessable value. And therefore, my lord, they assailed the order of the Commissioner Appeals before the tribunal on valuation. The tribunal decided the valuation. And my lord, they have come up to your lordship, my lord, therefore it is not maintainable. Is my respectful
This appeal has been filed by the revenue.
My lord, only one thing, my lord, I was very humbly submitted, lordship. Since this point has come up from my learned senior friend, If you kindly gives me a week's time, I will consider
Not
come back.
required, sir, not required. This appeal filed with the revenue is directed against the order passed by the Customs, Excise and Service Tax Appellate Tribunal, Kolkata, in Customs Appeal number 71290 of 2013, dated 10/5/2023. The appeal was filed by the department before the learned tribunal, challenging the adjudication order. Challenging the adjudication order or appellate order?
Commissioner appeals order.
Order passed by the Commissioner within bracket appeals, Kolkata. The learned senior advocate appearing for the respondent raised a preliminary objection as regards maintainability of this writ petition, and by referring to section 130 capital E of the Customs Act 1962 within bracket the Act. Reliance has been placed on the decision of the Honorable Supreme Court in Commission of Customs Bangalore versus Motorola India Limited 2019 368 ELT 3 within bracket SC. In the said decision, the Honorable Supreme Court.
Paragraph 9, my lords.
Yes, yes.
Obliged.
In the said decision, the Honorable Supreme Court, after referring to section 130 capital E of the Act, pointed out that upon a conjoint reading of the provisions, it could be seen that an appeal shall lie to the High Court against every order passed in an appeal by the Appellate Tribunal, if the High Court is satisfied that the case involves a substantial question of law. Full stop. The only exception carved out is that an appeal shall lie before the Honorable Supreme Court and shall not lie before the High Court against the order relating, among other things, to the determination of any question having relation to the rate of duty of customs or to the value of goods for the purpose of assessment. We have perused the adjudication order, order in original dated 29th January 2013, and we find that the matter relates to valuation of a car which was imported, and the valuation adopted by the importer respondent was rejected by the adjudicating authority, and the value was redetermined in terms of the provisions of the Customs Valuation Rules, 2007, read with the relevant provisions of the Act. The said order was appealed against by the respondent importer, and the appeal was dismissed by the Commissioner within bracket appeals, Kolkata. Agreed by the same, the revenue had preferred an appeal before the learned tribunal, and as rightly pointed out by the learned advocate appearing for the respondent, that in the memorandum of grounds of appeal, the only question canvassed by the revenue was that the transaction value cannot be ascertained on the basis of any of the invoices submitted by either the dealer based in Dubai or the invoice raised in Japan. Therefore, the revenue sought to justify their stand, stating that the value has to be ascertained as per the provisions of Rule 9 of the Customs Valuation Rules 2007. The matter of 2007, the learned tribunal by the impugned order has dismissed the appeal filed by the revenue.
This finding is wrong because department is challenged this.
Holding that.
Let's para 4 at page 97.
Yes, sir, I've got it, sir.
I'm obliged. I've
held that. Holding that, the adjudicating authority has held that the proposed value in the show cause notice is not acceptable, and that the said order was not challenged by the revenue before any authority. Further, the learned tribunal has affirmed the view taken by the Commissioner within bracket appeals and held that the Commissioner was right Commissioner rightly held that the value adopted by the adjudicating authority is not acceptable in the absence of any other value of the said goods available at the time, and therefore held that the declared value is to be accepted. Thus, the matter concerns valuation of the imported goods, and there is a clear bar for this court in entertaining this appeal. Accordingly, the appeal is held to be not maintainable before this court. Next.
Item number 20.
Or Section 5 application is to be disposed of. There was a delay of 36 days.
No, it can't be condoned because they are entitled to raise object to when you file it there. There will be a delay. So it application disposed of. Next. Yes. Item 20. Yeah. Yes.
Now for the appellant. There is a delay of 135 days.
That Mr. Meity won't object.
My lord, 135 day delay may be condoned, appeal may be dismissed. No question of law.
Oh, that I will plead that.
No
That's
question
for,
of
that's
law.
for me.
We have heard Mr. Arji Chakravarti, K.K. Meity, delay of 139 days condoned. Let the appeal come. Next.
Deprivileged.
Item number 21.
And the amount involved, my lord, 1,50,000. They can, Mr. Chakraborty is appearing. Only 1,50,000.
We are appearing for 1 lakh.
Yes,
The question is not about the amount. The question is all about because this decision, this order will have an impact on the future business. It's a return goods. Once duty paid cleared, returned, department is saying for the fresh sale again, I have to pay duty again. That is the question which have a serious impact on my future business.
Failed to fulfill the condition of the exemption.
I will show you, Lordship.
Yes. Next. Item 21.
Your Lordship, the advocate on record for the appellant has not been able to come to court
For the
because
respondent.
I'm appearing on behalf of respondent number 1.
Delay, we can condone 139 days.
Yes, Your Lordship.
If we are asking your.
Your Lordship, I do have objection about it because properly.
No, 75 days.
25.
We will record that you vehemently objected.
Your Lordship, I bow down to Your Lordship and.
We have heard so and so appearing for the appellant. There is a delay of 75 days in filing the appeal. The learned advocate appearing for the respondent would vehemently oppose the delay. After considering the submissions and after perusing the reasons set out for not preferring the appeal within the period of limitation, we are satisfied that sufficient cause has been shown for not preferring the appeal within the period of limitation. Hence, the delay in filing the appeal is condoned. Application is allowed. Next week it will come. Appeal will come. Next.
Obliged, Your Lordship.
Item number 22.
22.
This is my appeal. And on the last occasion, my learned friend has given an affidavit where he says that in this particular impugned order is against a 263 order. Now, consequently, there was another proceeding that happened before the 263, and consequent to section 253, there was a tribunal order also. This tribunal order is also there, my lord. My lord will kindly come straight away to the tribunal's order.
But what their stand is, this appeal has become infructuous.
Their stand is appeal has become infructuous. My stand is it is not infructuous for the reason, my lord will see the order first. Order is at page 20.
Yes.
My lord, I straight away take my lord to the corner. My lord, may I, my lord, kindly reads from paragraph 5. May I place paragraph 5? Because in this case, my lord, the finding is in my favor. The finding is in my favor. In the last paragraph, the tribunal comes to the figure that is given comes different from what figure it comes in the finding. I will kindly see paragraph 5. May I place paragraph 5? We have heard the arguments of both the sides and also perused the relevant materials available on record. Learned counsel for the SSC has submitted that the order passed by the assessing officer under section 143, 147 of the Act on 19/3/2016, disallowing the SSC's claim for depreciation to the extent of 8 crores 43 lakhs for assessment year 9-10 was challenged by the SSC in the appeal filed before the learned CITA appeals. This is the appeal that my learned friend is also talking about. And the learned CITA appeals, wide his appellate order dated 30th October 2019, deleted the entire disallowance of 8 crores 43 lakhs 55,800. So the Commissioner Appeals deletes that 8 crore 43 lakh made by the assessing officer on account of depreciation. He has submitted that the assessing officer, while giving effect to the said order of the learned CIT appeals dated 30th October 19, has recomputed the loss of the SSC company for year 2009-10 at rupees 19 crores 10 lakh 76,892. Madam will kindly keep a note of this amount. 19 crores 10 lakh 76,892, which inter alia includes business loss of 3 crore 99 lakhs 13,429. This is the amount of dispute. 3 crore 99 lakhs, which they want a set off in 15-16, which was available for set off against the income of the SSC for the year under consideration, assessment years 15-16. So because it was this disallowed was upheld, therefore this amount 399, now they become eligible to get that set off for 2015-16 according to. He has contended that there was thus no mistake in the order of the assessing officer dated 18/12/2017 passed under section 143(3), allowing the set off of brought forward loss amounting to rupees 3 crore 99 lakhs odd pertaining to assessment year 9-10. And the learned principal CIT is not justified in revising the said order by the impugned order passed under section 263. We are unable, now the finding, we are unable to accept this contention of the learned counsel for the SSC. It is observed that the assessment year for assessment year 15-16 was completed by the assessing officer wide an order passed on 18/12/2017. And even though the set off of business loss pertaining to assessment year 9-10 was claimed by the SSC to the tune of 3 crore 99 lakhs against the income for assessment year 15-16, it was incumbent upon the assessing officer to allow such set off only to the extent of loss as determined in the assessment. The undisputed fact in this regard is that the total loss of the SSC for assessment year 9-10 was determined in the assessment completed under section 143(3) wide an order dated 19/3/2016 at 10 crore 67 lakh 21,089 as against 19 crores 10 lakh 76,892 declared by the SSC. And since the entire loss so determined was already set off against the income of the SSC for assessment year 11-12 and 12-13, no loss as determined in the assessment year 9-10 was available for set off against the income of the SSC for assessment year 15-16 when the assessment order under section 143(3) for 2015-16 came to be passed by the assessing officer on 18/12/2017. In our opinion, there was thus an error in the order of the assessing officer passed under section 143(3) in allowing the set off of the loss of 3 crore 99 lakh pertaining to assessment year 9-10. So he comes to a finding that it was an error that 3 crore 99 he was not eligible to get a set off for 2009-10 in 2015-16. And the same being prejudicial to the interest of the revenue, the order passed by the assessing officer under section 143(3) dated 18/12/17 was liable to be revised as rightly held by the learned CIT in his impugned order passed under section 263. We, however, find that the working made by the learned principal CIT. So till then, my lord, till 260, he upholds that order that no, he was not eligible for 3 crore 99 lakhs in that assessment year. Now he says, we, however, find that the working made by the learned principal CIT regarding the excess set off of loss pertaining to AY 2009-10 alleged to be wrongly allowed by the assessing officer is not correct. And this matter, so he's talking about the working, and this matter should have been left open by him to the assessing officer for making the working on the basis of actual loss pertaining to assessment year 9-10 as determined in the relevant assessment. And this, there is no, he does not give any reasons for for coming to this finding, my lord. We accordingly modify the impugned order of the principal CIT passed under section 263 to this extent. So he modifies that to that extent that assessing officer will. Well, as regards the appellate order dated 30th October 2019 passed by the learned CIT appeals for assessment year 9-10. This is the other wing of the list that was going on. From the assessment order, they went to the Commissioner Appeals. Commissioner Appeals upheld that the disallowance, and then there's a tribunal order to that also, which I'm coming to, my lord. Allowing the entire claim of the assessee for depreciation and the effect given by the assessing officer to the said order, finally determining the loss of the assessee company for assessment year 9-10 at rupees 19 crores 10,76,000. So again, he comes to 19 lakhs. This figure, if my lord sees in the earlier page, was 10 crores odd. He comes back, he gives a finding why it should be 10 crores there. And now he comes and puts this figure of 19 crores 10,76,000, on which a strong reliance was placed by the learned counsel for the assessee at the time of hearing before us. We may clarify that the assessing officer, after having given effect to the order of the principal CIT and determined the loss of the assessee for assessment year 9-10 at rupees 19 crore 10,76,892, which inter alia included business loss of 399,13,429, which was available for set off against the income of assessee for 15-16 as claimed by the assessee, duty bound to allow such set off by passing a consequential order. It's absolutely contradictory. It's absolutely contrary. The finding is something and he orders something else.
But now, on account of certain other, as you said, other parallel proceedings which are going on.
The parallel proceeding.
Ultimately, in 2022, the assessing officer has allowed this setup.
Assessing officer has allowed the setup of two reasons, my lord. One,
that order has become final.
My lord, that order as well as this order had become final. Both. Now that order became final because in this order 19 crores was there. My lord will now see that order.
Then you should have challenged that order.
No, I have challenged this order. Crux is this order, my lord. First.
See that. In fact, in 2019, parallelly that proceedings are going on. 2019, the CITA passed an order and computed the carry forward loss for 9-10 and making the entire loss of 399 available for the respondent as a set off for the assessment year 15-16. And this was allowed by the assessing officer in November 2022, and he was allowed to have a set off that attained a finality.
That was because in this order, this error was there. Where this order says 19 crores, that order also says 19 crores.
Then, as against the order passed by the CIT appeals in October 2019, you should have filed an appeal to the tribunal.
They had not filed an appeal. It was confirmed.
There was an appeal to the tribunal. That was confirmed by the tribunal.
Against which no appeal
against which there is no appeal presently is there, my lord. As far as I have been informed, that an appeal has been being filed against that one.
Now afterthought.
It's not afterthought, my lord. Even here I have come after 900 days. I always come with a handicap before my lord. But it's palpably...
is that appeal number?
No, it hasn't been filed yet, as far as I know. My lord. But my lord, this is palpably wrong. It is palpably wrong.
But then this has worked itself out, sir. How, by assuming we allow this appeal.
My lord, then minute the second appeal comes in, the other...
No, that we can't allow. As on date, if we allow this appeal, that we will be indirectly setting aside an order which is not before us.
My lord, my lord, kindly seize that order.
It is not a... See, sir, there are cases where you file an appeal. In terms of the provisions of that, you are bound to implement the order passed by the appellate authority or the tribunal. It is not this way. This is a parallel line which is going on. Probably this 399, this figure got crystallized because of this order.
Yes.
You didn't come on appeal on time.
My lord.
So by virtue of this 957, that will be put to prejudice.
My lord will then see this Commissioner Appeals order was before this tribunal, before this impugned order.
We don't know about it.
But it is there.
It is there, but that tribunal...
After considering that, this has been passed.
So, but then, if you had been promptly...
But this is an anomaly. This is an anomaly for that public money will not,
On
ought not to be.
18th December 2020, tribunal passed this order. What is your limitation period? That you are conscious of the fact that there was another parallel proceedings going on.
My lord.
And according to you, this is an erroneous finding of the tribunal.
I was conscious of the fact, and
But then
that came in later after this, my lord, after this order.
No.
The 20, this is 20. Tribunal orders of 20.
CIT appeals order is 30th October 2019.
That's correct. And this was brought before this before the notice of this this
That
tribunal
order
also.
stood affirmed by the tribunal. Thereafter,
That was in 22. My lord, that happened in 20.
22 filed this appeal. You filed this appeal.
Okay, file
2023, December 2020.
And my another point, if I may make, my lord, in fact, no litigation remains because even if assuming the give effect order is passed, your lordship, following the 263 order, in that the assessing officer blindly disallowed 3.3 crores 99 lakhs. I filed a rectification petition
150.
in 154. That has been allowed. In that, my lord, the loss has been allowed. Now, where does the
always be
litigation? No. He can always reject it, saying if the litigation is pending or something. But my lord, he's allowed it in rectification under 154. So, my lord, now where does the litigation remain? Your lord,
on that
in my
particular
affidavit,
day,
my lord,
he had to allow because all these
No, in the
both the
assessment,
orders
he
were
did not-
staring on his face.
in the assessment order, he did not allow it.
This is a clear afterthought. After everything is attained a finality, in 16th November 2022, you have sanctioned allowed the set off. Then somebody gave an opinion and you filed this appeal on
No, my
11,
lord,
12,
this was pending before the Ministry of Law for a long time. It's a fact. I can't say anything more than this, my lord.
We have heard the advocate Salpat. There is a delay of 940 days in filing the appeal. The delay is vehemently opposed by the respondent assessee. Apart from that, assessee by filing an affidavit in opposition, and in the said affidavit, the assessee has set out the following facts to contend that the appeal filed by the revenue, has become infructuous. For better appreciation, the government set out in the affidavit in opposition is quoted here and below.
My lord then kindly dismisses this on the ground of delay, not on the substantive part.
No. We have heard you. Yes, sir, in the affidavit in opposition, page 8, para G, small g, page 9, para H. Page 10. The above facts are not in dispute, and it is seen that much prior to the order passed, or much prior to the impugned order passed by the tribunal, dated 18th December 2020, the assessee, an order was passed by the commission CIT within bracket A, dated October 30, 2019, by computing the carry forward loss for the assessment year 2009-10 to be 19, 10, 76, 892, and making the entire loss of rupees 3, 99, 13, 429 available to the assessee for set off in the assessment year 2015. The assessing officer, by order dated 16/11/2022, allowed the claim of carry forward of loss of 3, 99, 13, 429 in the assessment year 2015-16. Thus, as noted above, the present appeal has been filed before this court by the revenue only on 11/12/2023. Thus, nothing survives for adjudication in this appeal, and the same is dismissed. Next.
I'm grateful, your lordship.
I not 23. Grateful, my lord.
291 days. Respondent, sir. Mr. Sen, you are appearing.
My lord, the department's appeal.
You are objecting the delay.
I'm filing
My lord, there was an affidavit direction, my lord. I have served a copy of reply to my learned friend.
Yes, my lord. He has
I believe
given a
yes.
copy today, my lord.
Today,
Next week we will have.
As it pleases your lordship.
Affidavit in opposition and reply has been filed. Request next week.
Grateful, my lord.
Item number 24.
This matter, my lord, similar matter
Hearing
was.
for the appellate in this case.
Yes,
Uh, Your Lordship, the assessment order is already passed in my favor. Therefore, we want to withdraw this appeal, Your Lordship. They have accepted our return income, my lord, via order dated 19/3/2024.
19/3.
19/3/24, my lord.
24.
My lord.
We have heard Mr. Subhash Agarwal and Mr. Brijesh Kumar Singh for the appellant and Mr. Samrajit Roy Chaudhary, Learned Sandy Counsel for the respondent. It is submitted by the Learned Counsel for the appellant that the appellant seeks to withdraw this appeal since the assessing officer has passed orders in favor of the appellant on 19/3/2024. The said submission made on behalf of the appellant is placed on record and the appeal is dismissed. Next.
Deeply obliged, Your Lordship.
Item number 25.
I beg to appear on behalf of the appellant.
I am for the defend number, respond number 225.
My learned friend is the successful writ petition.
No, I am not the petitioner. I was for the other respondents.
Pardon?
I was for the other respondents, the former respondent.
The writ petitioner succeeded, in an action, challenging the surface measures taken under the Securitization Act against by a private bank. Our grounds of appeal, may I just indicate the broad grounds. Firstly, we say that the writ petition was not maintainable on two scores. Firstly, section 17 remedy was there, which was not available. No explanation provided what could have prevented them. This writ petition was filed. March after the time limit given in the under the act had expired. That 45 days time. This was filed against a private bank. This was filed on an allegation that a property of which the writ petitioner tried to project himself as a tenant was not mortgaged to the bank. No document in support of this alleged tenancy was.
The learned judge has decided the maintainability.
Yes, that has gone against us. The learned
which paragraph?
But this maintainability point was never argued. I was there in the court below. This point was never argued.
And this has been
This
decided.
point was never specifically said that it's private bank and therefore writ petition. Although I was not the petitioner, but because I contested and I am the landlord.
The writ petitioner was set up by my learned friend. I will show that from the documents. Page 3, if my lord kindly turns to. Towards the middle, slightly down below, there is a paragraph starts with upon hearing the learned counsels. Internal page 3, of the judgment and order imprint. From here, the observations, the findings of the Honorable Single Judge starts. If my lords kindly turn over the page. The next page deals with the maintainability point on both scores against the private bank and also on the basis of the section 17.
Private bank.
And the Honorable Single Judge was of the view since the property, according to the petitioner, was not mortgaged. So, this was not really a surface
Private bank issue was never argued. It's not recorded in the order itself. Kindly read, Milord. Probably.
It is not prime facie, it is not maintainable.
I am not the petitioner. I can't defend it, Milord, in any event. Milord, but Milord, this point of maintainability which my land is now saying.
Writ petitioner has been served.
Yes, Milord.
Where is your affidavit of service?
He was waiting here, Milord. Mr. Bordon was appearing for
he was
waiting.
Who appeared?
Mr. Orchip Bordon.
Lordship, I'm appearing on behalf of the petitioner. Kindly give me a short passover.
Pass over there.
May we come back, Milord, any other day, Milord, Monday, Milord, may we come back subject to my lord's
All right, Monday.
And kindly allow us, Milord, to take out, Milord, an application under Order 41, Rule 27. Because, Milord, we were not granted an opportunity to even put in our opposition. Milord, a commissioner was appointed, Milord, on the basis of the commissioner's report to which we put our exception. Milord, the writ petition was disposed of. Milord, we want to, Milord, bring only one document, Milord, on record, Milord, before your lordship, which was otherwise shown, Milord, to the Honorable Single Judge, to show that the property, Milord, which was mortgaged, there was an improvement on the Milord mortgage property after the mortgage had taken place. Milord, any improvement on the mortgage, post-mortgage is also a mortgage.
Only one thing, Milord, although Milord, I know, but Milord, my land friend was not there in the court below. Probably he's not Milord sufficiently instructed, Milord. this opportunity, my lord, of filing affidavit was given, was offered.
Well, he is
They
not
said,
going to be
I was
affected in
present,
any
my lord,
way.
in that court, my lord friend was not. They said they do not need to file an affidavit. There was an inspection at the instance of parties and the
Yes,
officer
he
went.
is the
court officer went.
defaulting borrower.
Yes, and I was,
Not his
but I was
petition.
borrower of a different property.
Put cash
This
hold of a
property- this
person
property was
who can
not
project
solved.
himself as a tenant without showing any
He wants
document.
a passover instead of, when will this matter come up? Wednesday.
Wednesday. Will kindly grant us an opportunity, Miller, to wait. Minute. Can be.
এই অরিজিৎ এসে গেছে বুধবার রাখছি
The first issue is maintainability. Sir.
Well, this is maintainable. Why will I say this property, which is the bone of contention, is not a secure asset in the first place? If it is not a secured asset, Muller, in terms of section 13 and 17, Muller, my door to the DRT is closed. So the first issue is whether this property is a secured asset or not.
But how do we decide that?
Muller, on admission, Muller, kindly seize the DM's order. DM's order, Muller, appears at page 49. Admittedly, Muller, I am a tenant of the second and third floor.
There is no admission. No
Fine,
admission at all.
Fine. Second and third floor. Allegation.
Not put minute words into my mouth.
Let me put it assumption. Muller, kindly seize page 49.
Yes.
The third paragraph, Muller. Then schedule of property. All that piece and parcel of mortgage property of a commercial space, ground floor. And thereafter, Muller, kindly seize all that commercial space on the first floor. So, Muller, the ground floor and the first floor are the secured assets. Muller, my case runs on the fact that I am in possession of the second and the third floors.
Half-baked fact, Miller, may I place my appeal then?
Now, on the date when the mortgage was created,
This is a two-story.
the property consisted of ground
Two-story
plus,
building.
ground plus first floor.
Yes. Yes.
And at what point of time the second floor was constructed?
Post-mortgage.
Muller, kindly, Muller, to that, Muller, let me take instruction come on Wednesday.
I have document to show
Muller,
that.
kindly,
Here and
on Muller, the point today is whether.
Sir, this will open floodgates.
No, Muller, there's no question, Muller. There's no question of opening floodgates, Muller.
Deprecated, Miller, by
First
the
of all,
House Supreme.
if suppose construction had been put up by the owner of the property, when the property was subject matter of mortgage, the fine print in the mortgage deed will always say that the mortgagee has to be put on notice, and because there will be value addition to the property, and whether the construction is authorized, unauthorized, etc. So without his permission, without the bank's permission, you cannot put up any construction. So assuming some improvement has been made, tenant has done something with the consent of the landlord, then it goes without saying that whatever is appurtenant to the mortgage property is also subject matter of mortgage.
Yes.
You can always defend this issue by leading evidence, saying that this was done with the knowledge of the bank, or there was an arrangement between the owner and the bank, exchange of communications. So it is not as if that the bank was not aware. See, the concept is the building has not much value. It is a depreciable asset. So the property in question, which is subject matter of mortgage, is the land. It is no doubt the mortgage created with land and building. So to put up a second floor on the property, it should be duly supported by the requisite undivided share in the land. If that requisite undivided share has to be traced within the four boundaries of the existing property. Therefore, if you put up a second floor, it means that you have taken 1/3 of the share, assuming all the three floors are in equal proportion. 1/3 of the share should be allotted notionally or imaginatively, because nobody can point out where is your
exact undivided share. I understand.
This is impermissible. A mortgage asset cannot be.
May I say this, Manoj? May I come back on Wednesday?
We'll hear the appeal.
And here's the appeal.
We have heard the learned advocates for the parties. Prima facie, we are satisfied that the writ petition was not maintainable for more than one reason. Firstly, the appellant is a private.
If my lord kindly passes, my lord, if my lord kindly passes the observation, my lord, the writ, my lord,
No.
nothing written
My
in the
lord's
appeal.
observations.
It's
I
a
am entitled to
private
make my
issue.
submissions.
The appellant is a NBFC.
And I mean,
The issue would be as to whether, and the other issue would be whether the writ petitioner who claims to be a tenant in the second floor of the building, which is said to have been put up after the mortgage was created, has any semblance of right. The concept of undivided share in the land has to be borne in mind, and a construction cannot be put up dehorse a right in the land. Thus, assuming the construction was put up by the landlord after the mortgage was created, without the consent of the appellant finance company, then it goes without saying that a part of the mortgage asset is also being utilized by the borrower for the to support the construction in the second floor. If that be so, then they said, then the any further construction put up on the mortgage property will also be covered under the mortgage. This is a prima facie finding recorded by us for the purpose of entertaining this appeal. However, the court will hear the learned advocates for the respondent after affidavits are filed if they so desire to do so. In the light of the above, the order and direction issued by the learned single bench in the impugned order shall remain stayed.
But kindly, Millard, prevent both of us, Millard, from further alienating the property.
No.
Kindly prevent both of us.
I say I'm a tenant. How can you alienate?
It goes without saying that neither the appellant finance company nor the respondents are entitled to create alienate the property in question, namely the land as well as the building consisting of ground plus 2 floors, nor alter the physical features of the property till the disposal of this appeal.
No, grateful.
Next.
Millard, this, Millard, in effect stops me, Millard, from alienating, Millard, the undisputed floors as well. So, Millard, kindly restrict, Millard, this order of injunction to, Millard, the second and the third floor. Ground and first floor, there is no dispute. None is, Millard, claiming any right.
No, I don't.
No. But you fight the case as entire property.
Millard will come back.
They cannot blow hot and cold. Well, I'm so grateful.
Hot and super hot.
Next.
Item number 26.
26.
My lord, item number 26, I am for the appellant. I am led by my lord, senior advocate, Mr. Joy Shah, who is not in Calcutta today, my lord. He was praying, subject to your lordship's convenience, if the matter could appear on Wednesday.
I pay for respond number 2, bank.
At the request of the learned advocate for the appellant, next Wednesday.
I'm grateful, my lord.
Item number 27. Item number 27. Item number 28.
My lord, in this matter, I am for the respondent. The tribunal has decided 13 appeals in a consolidated order. The department has come only against
in
two
respect of
appeals.
2.
Your lordships on the last occasion were pleased to direct them
to find out.
In respect of the other SSCs, my lord, it is much below the threshold limit. So only in this two, particularly 28, 29 has come up for appeal.
What is this matter?
If your lordship kindly comes to the question of law at page 5, my lord. Initiating of the proceedings and the issuance of the notice under section 153A against the non-existing company. Now, there was an amalgamation which took place in the year 1st of February 18, my lord, it was issued, and the order of amalgamation was 5th of January 2018 with effect. It was effective from 1/4/15, my lord. Now, their contention is that everything has been issued and initiated against the amalgamated company. Now, if your lordship kindly takes up page 83.
Yes.
Now, SEC's contention is that it was already intimated to the assessing officer. So when was it intimated? The AO was intimated of the amalgamation order on 23rd of July 2018. But the SSC, they have not taken any steps for the merger of the PAN, my lord. So until unless they take a step for the merger of the PAN, even if it has been intimated to the assessing officer, that remains, and they will not take any steps against the amalgamating company. Now, this is also the contention of the CITA, my lord, that it is curable. It is curable. It is can be so the jurisdictional issue, and as such, the reassessment proceedings cannot be invalidated, and also relying upon the skylight and also that Maruti Suzuki, my lord, that it can be cured. This defect can be cured under section 292B. It will not invalidate the reassessment proceedings. Page 89, paragraph 7.
That spice infotainment judgment you have carried?
Spice infotainment.
You got copy of Skylight you have got? No.
Skylight I have.
The Maruti Suzuki is also there, my lord.
In the Maruti Suzuki case, my lord, this Skylight hospitality was distinguished.
Actually, they are disputing the same on facts. They say that the notice under section 153A was served on 1/2/2018, not on 23/7/2018.
My lord, the case of the SAC is kindly take page 85, my lord, is the submission of the SSC before the tribunal. The learned heir vehemently submitted before us that the notices have been issued and assessment was framed in the name of non-existent entity, that is the name of the amalgamating company, which had already merged with the amalgamated company by order dated 5th of January 2018 with effect from 1/4/2015 passed by the Kolkata bench of National Company Law Tribunal. The learned heir submitted that the assessment so framed was invalid and bad in law. The learned heir submitted before the bench that this fact was brought to the notice of the investigation wing as well as the learned assessing officer that the SEC has merged with the other company, but the same went unheeded. And kindly.
No, according to the tribunal, in para 9, they say there is no dispute as to the communication with the SSC to AO, which has been done by 2 letters on 23/7/18 and 22/11/18. But the notice under 153A was issued on 1/2/2018. That is their substantial question of law number 2.
My lord,
Actually, there appears to be a mistake.
but the facts remain that the SSC has intimated this merger.
On what date? That's the issue. All right, we'll consider. Sir, please come. A, B, C, D, admitted. Next,
Same, my lord.
two matters, yes.
Item number 30.
And I'm appealing for the respondent SSC Miller. But before my learned friend starts, my lord, I am raising a preliminary objection on the ground of maintainability. My lord, from the assessment order, SSC had preferred a first appeal before the learned CIT. Like in the meantime, during the pendency of the appeal, my lord, the department has invoked section 263 jurisdiction, my lord. On that ground only, I am objecting.
Yes, that is the reason, my lord. That is one of the issue of the appeal itself. I am, my lord, indicating certain dates. My lord, kindly take note of the date of the passing of the assessment order. Because one of the issue whether, my lord, the 263 jurisdiction can be exercised, my lord, while CIT appeal is pending. That is one of the aspect, and that is main subject matter of this appeal. That's why, my lord, these dates are important. Lordship, kindly take note of the date of passing of the assessment order. That is on 29th November 2019.
29th November.
2019 is the date on which assessment order has been passed. Then, my lord, 263 order has been passed on 1st of March 2022. And in between, my lord, the SSC has, my lord, carried out an appeal assailing that assessment order, and that appeal has been decided by the CIT appeal on 1st of June 2023. So, my lord, on the date of passing of, my lord, the 263 order, the appeal did not reach to its finality. So, my lord, 263 order was, my lord, on this. This is one of the ground that whether, my lord, at the time of passing 263 order, CIT appeal was pending. So, is it debarring, my lord, the 263 order to be, my lord?
What does the tribunal say?
The tribunal, my lord, it starts at page 24.
There are more than one issue, is it?
Yes.
Which paragraph they decide 263 issue? Page 30.
My lord.
My lord, page 30.
The page 37 is the relevant portion.
No, on the date when this 263 was issued, no proceedings were initiated. Appeal was pending.
Pending,
was
my lord. Pending, my lord.
Appeal was pending, but
So therefore it will result in contradictory orders.
now, my lord, if your lordship kindly see, my lord, the subsection 3 of 263, which itself, my lord, attempted to, my lord, deal with the situation like this. I'm placing that before lordship.
It is quoted here in this order.
Yes, yes.
Notwithstanding anything contained
Contained in
in
subsection to an order in revision under this section may be passed at any time in the case of an order which has been passed in consequences of or to give effect to any finding or direction contained in an order of the Appellate Tribunal, National Tribunal, the High Court or Supreme Court. So, my lord, this has been, my lord, specifically incorporated for the purpose of dealing this. So, the issue boiled down to the point that whether, my lord, when 263 jurisdiction has been exercised, may at pendency of an appeal debars the jurisdiction under 263 or not.
But how will you get over class C of section 263(1)?
Yes, ma'am.
But moreover, my lord, the Commissioner of Appeals has all party allowed the appeal. They have not preferred any appeal from that order. Ground number 4 was deleted, which is there in the allegation which is made by them. That has been deleted by the Commissioner of Income Tax, white ordered 1st June 2023. Now, if your lordship sees page number 58.
58.
58, my lord. Proceed, the undisclosed sundry debtors, my lord, at the bottom, my lord, 6.2.6. My lord, the last line, my lord. Hence, the addition made by the SSC officer amounting to rupees such and such on account of unexplained sundry debtors is deleted at the ground floor is hereby allowed. So any effect of applicability of tax, Lord, does not arise.
And this was an order passed by?
First appeal, CIT appeal, my lord. From this, they have not preferred any appeal.
This 1 crore and odd was the subject matter of 263.
My lord, yes.
No.
The rate
no.
of tax that the allegation which they have made, the rate of tax, it should have been taxed at the rate of 60%, the special rate. My lord, this is
155 BB.
If this, yes, my lord, if this is deleted, my lord, then the subsequent question of rate of tax does not arise.
Please take down this appeal filed by the revenue under section 260 capital A of the Income Tax Act is directed against the order passed by the Income Tax Appellate Tribunal A Bench Kolkata in ITA number 198/KOL/2022 dated 13 January 2023 for the assessment year 2017-18. The revenue has raised the following substantial questions of law for consideration. Page 4, question 2, 3. We have heard sounds. After elaborately hearing the learned advocates for the parties and carefully perusing the materials placed on record, we find that on two grounds, the appeal filed by the revenue cannot be entertained. Firstly, on the date when the proceedings were initiated under section 263 of the Act, and statutory appeal before the Commission of Income Tax within bracket appeals was pending. This fact is not disputed and rightly noted by the tribunal in paragraph 14 of the impugned order, wherein the learned tribunal has examined the scope and ambit of section 263 within bracket 1 within brackets small c of the Act. The said finding recorded by the tribunal to hold that proceedings under section 263 of the Act could not be invoked is well justified and does not call for any interference. The Commission of Income Tax Appeals, in a regular appeal filed by the SSC, has passed an order on 1/6/2023 by which an amount of rupees 1,02,60,638 on account of unexplained sundry debtors was deleted, and the SSC succeeded in the appeal. We are informed that as against the said order passed by the CITA dated 1/6/2023, no appeal has been filed by the department. Thus, we find no grounds to entertain this appeal dismissed. We'll stop with this.
Grateful, my lord.
Go down to your lordship.
My lord, only three matters, my lord, I will not be there. My lord, 34, 35, 36, but there is
34 I am there.
great.
35, 36. my lord.
Grateful.
Accident লাগবে
তো ভুলেই গেছে।
Item number 31, my lord, I beg to appear on the appellant, my lord.
My lord, I am for the
That is
respondent
no-
assessee, my lord. Kindly directed to serve the copy, my lord.
My lord, we have served,
In that
my lord, I will again serve, my lord. My lord, here, my lord, two issues. First issue is that, my lord, the principal CIT, my lord, passed order under section 263. The assessee took the point that the order is without DIN, without DIN number. Now, my lord, this matter was pending before the Honorable Supreme Court, and Supreme Court given a stay.
Yeah.
Second point is that, my lord, on merit also tribunal interfered. Tribunal relying the judgment of Kaushal dealers and affirmed by this Honorable Court, my lord, dismiss the appeal of the, my lord, revenue. But, my lord, distinguishable case because, my lord, here, my lord, the LCC investment made in NCC, your lordship kindly see, my lord, the assessing officer, my lord, categorically mentioned the, my lord, dealers, my lord, who are invested, my lord, that is, my lord, appearing in page. Page 54, my lord, your lordship kindly see. At page 54, my lord, last 3-4 lines. The information available with the, my lord, department was collected and further inquiries was conducted on this some of the entities which are purchased by the share of CCL International Limited. From the inquiries done, so far as it has been found that the following entities which have been purchased the share of CCL International Limited are Bogus and Penny entries, my lord. Thereafter, my lord, the given the Penny entries, my lord. But that is, my lord, not similar to the, my lord, order passed by your lordship and affirming by your lordship, my lord, in the Kaushal dealers. Here, 263 orders, my lord, passed, and your lordship hold that, my lord, 2 inquiries, my lord, did not follow. That's why your lordship, my lord, affirm the order of the, my lord, tribunal. Here, my lord, not the same case. Because here, my lord, only the, your lordship kindly see the order passed by your lordship in Kaushal dealers. Chaliye deben. Only, my lord, I have one copy. Here, your lordship kindly see, my lord, 3 notices issued to the, my lord, assessee, and assessee replied. And, my lord, 3 notices issued and assessee categorically replied to the notices. Here only 1 notice under section 143 1 was given. And that was replied by the assessee giving the bank statement and, my lord, auditor's balance sheet. But here is no scope for, my lord, the assessing officer earlier that he had made investment in the penny stock. Well, this matter only required to be, my lord, admission.
You serve papers.
My lord.
The appeal is admitted on the following substantial questions of law. Page 4 and 5.
And this is the, my lord, judgment of the, my lord, Honorable Supreme Court.
That Supreme Court stay order is
Yes,
this.
yes, stay order.
The learned the senior standing counsel for the appellant placed before this court the order passed by the Honorable Supreme Court in Commission of Income Tax versus Brandix Mauritius Holding Limited. 2024-159 taxman.com 247 within bracket AC, wherein the Honorable Supreme Court has granted an interim stay of the order of the High Court, where the assessment was set aside only on the ground that the order was without DIN. That's all. Then you whatever is the usual.
Your Lordship, please to admit the appeal.
Item number 32. Motion for the respondent assessing this matter.
This is my application, Your Lordship. May I be permitted to file the affidavits? Your Lordship kindly comes to page 4, the question of law. The tribunal's order passed at page
24.
24.
Yeah, it
That
is.
Your Lordship kindly comes to page.
See, finding starts at
36.
page 28, paragraph 7.
I'll be
It will-
relying for 36 also.
it will portions.
Paragraph 70. Initially, there was an order passed under section 143(1), subsequently taken up for the scrutiny, and then the 143(2), 142(1) notices issued, 143(3) assessment order passed, and then there was a show cause notice issued by the CITA, prejudicial to the interest of the revenue in respect of the two issues, my lord. The main issues with regard to the allowability of the interest expenditure claimed on the secured loans and the interest expenses. That partly they have paid and partly they have not paid, that the interest which has not been asked for from the related parties, my lord. Now, if Your Lordship kindly comes to the order of the 263 order, it starts from page 14. The page 15. That is, it is page 15, the bold portion of the paragraph, the second paragraph, my lord. That it was evident that no interest had been charged by the assessee company on the remaining unsecured loan. That is the number one issue. And the second one is that it is apparent there is excess claim of the expenses to the tune of 6 crores and thus resulting in undercharge of tax. Now, Your Lordship kindly comes to the order of the tribunal. Page 25. The entire show cause notice has been enumerated below, my lord.
No,
Paragraph
actually,
2.1.
The discussion is from para 17, page 36.
Yes, para 17, I'm also relying upon that. But prior to that, the show cause notice, which has been indicated in the paragraph 2.1, my lord.
Page
25.
Yes.
Subsequently, the learned PCIT called for the assessment records and observed that the certain issues have not been examined by the learned assessing officer and issued a show cause notice under section 263, which is placed at page 73 of the paper book, and the issue raised in the show cause notice reads as follows: that it was observed from the assessment records, particularly from the note number 5 of the balance sheet, as at 31st March, that the assessee company had outstanding unsecured loan to the tune of rupees 1 crore 15 lakhs taken from the body corporate and the repayable on demand. On the other hand, it was observed from the note number 12 of the balance sheet as at 31st March that the assessee company had given loans to the related parties amounting to rupees 54 lakhs and to others to the tune of 13 lakhs, aggregate to the tune of 67 lakhs. The assessee company had advanced a sum of rupees as interest-free loan to the related parties out of total loan advanced to the related parties. Further, it was noticed from the details of the loan given to the related party as submitted by the assessee company itself that it had charged interest of rupees 12 lakhs on the loan amount out of total unsecured loan given to the related parties. Thus, it was evident that no interest had been charged by the assessee company on the remaining unsecured loan and pertaining to the loan extended to the related parties or the sister concern. The records also reveal that the assessee company had debited a sum of rupees 12 lakhs to its profit and loss for the year ended as interest expenses on the unsecured loan taken from the related party, while the assessee had not charged any interest for this assessment year on unsecured loan and given to its related parties sister concern. As the assessee company had neither charged any interest on the instant interest-free loan nor disclose any such interest in its return of income filed by the department, the proportionate interest of rupees 6 crores or at the rate 13% of the 53 lakhs, consider the interest at the rate 13%, keeping the rate of interest paid by the SSC on unsecured loan taken from the related party. Now, your lordship kindly comes to page 26. In reply to the show cause notice, the SSC, now that is the SSC's contention, and then your lordship kindly comes to paragraph 7, page 28. The finding of the tribunal, that we have heard the rival contentions and perused the records placed before us and carefully gone through the decisions referred to by the learned counsel for the SSC, and the SSC is in appeal, assailing the order of learned PCIT for wrongly assuming the jurisdiction under 263 of the Act, and further urged in holding that the assessment order dated 13th of March under section 143(3) of the Act as erroneous and prejudicial to the interest of the revenue. The only issue referred to in the impugned order is regarding the allowability of the interest expenditure claimed on the unsecured loans. The principal CIT has observed that the SSC has taken the huge unsecured loans and has claimed the interest paid thereon as expenditure, but has not applied those funds for the purpose of business, but has given free loans to its related parties. And since no interest has been charged by the SSC company on the major portion of the loans given to the related parties, and the proportionate amount of interest expenditure deserves to be disallowed. Before proceeding to examine the issue stated, we find that the provision of 263 of the Act has the direct bearing. I'm not reading out like
You straight come to page 36.
36.
All fully factual.
Now, in the light of the above judicial pronouncements and the provisions of 263 of the Act, let us examine the issue raised in the order passed by the under section 263 of the Act, which relates to not charging interest on the loans given to the related parties. And we observe that the SSC company has outstanding unsecured loans to the tune of 115.94 crores taken from the body corporate, and as on 31st March 2018, loans were given to the related parties amounting to rupees 54.50 crores and to others 13.35 crores. SSC company has advanced a sum of rupees 53.13 crores as interest-free loan to the related parties, and out
No,
of the
that's all on facts, Smita. You will leave it. Ultimately, what does the tribunal say? The assessing officer had issued notices under 141, 142, etc. They submitted elaborate reply statements, etc.
No, but if your lordship kindly takes up the assessment order under section, passed under section
assessment order
143,
maybe,
no inquiry, nothing was made by the assessing officer. And the tribunal is holding that no, the inquiry and everything has been done. No independent inquiry, nothing has been done. If your lordship kindly takes up, it's a 2-page order, my lord. It starts from page
No, the earlier matter,
11.
Woman had produced a stay order copy. DIN number, no? We have also
Yes, my lord.
Now that judgment has been stayed. It's a 3-line order. Do you mean to say that nothing was considered, and as soon as the Solicitor General stood up, Supreme Court granted stay? No. So that's why there are judgments to say that nobody can tell the assessing officer as to how he has to conduct an inquiry. But his process should be fair and reasonable, should not tantamount to harassment. Assessee can be called upon to produce any documents. He is bound to cooperate. Third-party information can be gathered. Notices can be issued for people to appear as witnesses also. So this is the power. So that's why they say you don't direct the AO to do it in a particular file. You can't do it. However high in the hierarchy of authorities, even the PCIT, you can't tell him how to do it. That's why the tribunal examines all these facts. Now, where are we to break the head? Probably he has been a very smart chartered accountant. They have made up the issue. So it's the duty of that. If at all you have to pick holes in this, you will have to should have established that before the tribunal. And the tribunal says the detailed reply was filed, assessing officer making proper application.
That is the finding of the tribunal. But if your lordship kindly
Paragraph 18, they have detailed inquiry has been made.
So all right, if you want, they can file their entire compilation.
It is there, your lordship.
You give copy to Smith. Don't give it to us. You keep reading all these things, what little black hair we have, that will also turn white.
No, these are all factual issues. It goes without saying that it is because they have not gone into it, and then the tribunal has arrived at a finding. No, everything, all inquiry and independent inquiry has been done. But these are only the two issues before your lordship, and that needs to be probed into, and maybe that the tribunal has say, because sometimes it happens they don't produce it before the assessing officer, and subsequently before the tribunal or before the CITA, they keeps on producing. And
In
so
fact, the previous case, that's why we admitted. Wonderfully planned. Even in that penny stock batch, apparently you turn the book from right to left, nothing will be seen. That is why we adopted a theory of working backwards. So the investigation came in the reverse direction, led to the investor assessee. Poor people and innocent people who had no inkling about any share trading or etc. They were used as fronts. But still this is how the investigation proceeded. Anyway, thanks. This appeal by the revenue by under section 260 capital A, Income Tax Act 1961 was directed against the order dated 25th August 2023 passed by the Income Tax Appellate Tribunal A Bench Kolkata and ITA number 440/Keval 2023 for the assessment year 2018-19. The revenue has raised the following substantial pieces of law for consideration. Page number 4, A and B. You have heard Smita Deste, Pratyutoria, Swapna Das, Siddharth Das. The issue which fell for consideration before the tribunal was whether the order passed by the Principal Commissioner of Income Tax within bracket PCIT under section 263 of the Act regarding allowability of interest expenditure claimed by the assessee on unsecured loans was correct and warranted. The argument before the learned tribunal as placed by the assessee was with regard to the exercise of power under section 263 of the Act. The learned tribunal has referred to all the decisions on the point, including the decision in Malabar Industries 243 ITR 83 to point out the principles under which the PCIT would be entitled to exercise its jurisdiction under under section 263 of the Act. Thereupon, the tribunal has embarked upon a fact-finding exercise, and the finding commences from paragraph 17 of the impugned order. On perusal of the impugned order, we find that the tribunal has analyzed the factual position and all the documents which were placed by the assessee in the form of a paper board, and found that the assessing officer had issued notice to the assessee, called for information, discussed the case, and thereafter completed the assessment under section 143 within bracket 3 of the Act. Therefore, the tribunal on facts came to the conclusion that it is not a case of no inquiry conducted by the assessing officer, rather a case where inquiry was conducted, documents were produced, and thereafter the assessment was completed. Thus, in our view, the learned tribunal cannot be faulted for having reappreciated the factual position and come to a conclusion in favor of the assessee. In the result, we are of the view that no question of law, much less substantial question of law consideration is dismissed. Thank you. Next.
Item number 33. Lord, I'm appearing in this mess. It was served, to return back with the endorsement insufficient addressment. The Lordship will kindly fresh service, it's 148 issue.
Fresh notice.
Fresh notice or email service also.
Fresh notice to the respondent. In addition, email.
Great.
Next.
Item number 34.
Well, 34, Mr. Rai is appearing before recess,
Appellant.
Mr. Rai had mentioned before.
You argue.
Why not? I don't.
When you are going to start, you need to start. We will share one stay petition.
Fine.
And,
Kindly,
what is the issue?
Lord, the issue is pertains to Mr. Section 263. Now, my lord, the SSC before your lord.
Admit the appeal?
My lord.
No.
My lord.
It is your appeal or his appeal?
It is my appeal, my lord.
Then we will admit.
And Mr. As per my instruction, Mr. Rai.
Yes. Instruction overruled. That is why we told Mr. Rai, as and when the matter reaches, we will take it. 100 appeals are filed. 97 appeals are by the revenue. 1, 2, 3, rarely the SSC comes. And how many appeals of the revenue we have entertained? Where are the questions?
At paragraph 45, page 30.
30.
My lord.
My goodness. Stay petition.
It starts at page 31 of the stay petition, my lord.
30.
Last paragraph, and it goes on to page 31.
In fact, question number 1 and 2 will cover everything.
Lord, subject to your lordship's kind question number 4 also, my lord. Question number 4 also will be very important, my lord. Because, my lord, the inquiry generated from whether I have deducted tax at source. But question number 4, which I have
we'll admit it. Sir.
Well, next week, kindly fix the next week.
No, we can't hear the appeal without admitting. We have heard Mr. So-and-so and so-and-so. Appeal is admitted on the following substantial questions of law.
Question number 4 also, my lord.
1, 2, and 4.
I'm grateful.
Om Narayan Rai accepts notice for the respondent revenue. You want paper book? No paper book.
Lord, the paper book may dispense with all the.
All right. Since all documents are annexed in the stay petition,
no,
filing of informal paper book.
No, my lord, the paper book I'll
informal paper book is dispensed with. However, if the assessee or the revenue wish to place any records which were placed before the tribunal, they are at liberty to do so by filing a compilation.
I'm grateful.
You save on money.
The affidavit of service.
Affidavit of service taken on record. Next.
35 and 36.
35 and 36, my lord. SM Surana reading this matter, my lord.
He's appearing online.
My lord. By virtually, my lord. SM Surana.
This is the same Mr. mentioned before your lordship, my lord. My lord, kindly
take up the matter Wednesday, my lord.
Where is Mr. Surana?
Kindly adjourn this matter, my lord. Next week.
Next week.
You ask him to log in.
Kindly adjourn this matter, my lord. Take up this matter next week. 35 and 36.
You are not able to establish anything before the tribunal. Nothing is there. Concurrent finding of facts. Once again, tribunal found out how the modus operandi, some purchases, bogus bills. and the estimation is only 12.616%. Reasonable estimation. Where the question of law is there, sir? This appeal by the assessee under section 260 so and so Act is directed against order dated 30th November 2023, passed by the Income Tax Appellate Tribunal, C Bench, Kolkata, and ITA number 138/2023 for the assessment year 1314. The assessee has raised the following substantial questions of
My
law
lord,
for
kindly
consideration.
take up this matter, my lord, next week, my lord.
All right. Strike up. Adjourned.
My lord.
35, 36. Next.
Item number 37.
What is this? Customs broker.
Yes, ma'am.
No, well, this is central excise.
It is central
Penalty,
excise.
penalty.
Central excise.
As well, Central Excise Act, my lord, I have tried to formulate the questions of law at page 9, paragraph 3. I will be placing, my lord, question of law at page 10, D, E, and F. D, E, and F.
D, E, and F.
But Jai Balaji Industries and Prasanta re-rolling, that no appeal filed.
I don't know. I'm
It
not
has become
aware.
final.
But against the same party. The problem is the whole issue starts with, my lord, will find that question F, the last part, it all relates to the recovery from Sri Parashnath re-rolling. Now, Joy Balaji is one purchaser. I am another purchaser. Tribunal passed order in Joy Balaji's case holding that those documents cannot be relied upon in respect of Joy Balaji. But in my case, relied upon the same thing. This is their own final order. On the same facts, two different purchasers only. And and the whole question, my lord, I am putting it to myself. If my lord sees rule 26 of the Article Central Excise Rule, it says that if the party against whom the duty demand is there, if he pays it, everything finishes. No other will be penalized even. So unless it is determined what happened to Sri Parashnath re-rolling mill, this cannot be done.
And does the tribunal distinguish that decision?
Correct.
No, you have
No, not even, not even.
You would have referred to this two decisions. What is the finding of the tribunal on those?
Yes, yes.
Have they held that for XYZ reasons it's not applicable to your case?
No, not written. Not written. Not even referred to.
Probably not placed.
Not may not be placed. Well, I was not there, my lord. I was not there, my lord. So I
That
cannot.
has not been stated in the tribunal's order.
No, not stated. I am saying that only. That is not referred in the tribunal law.
But it is if both of you have purchased it from the same person.
Same. Parashnath re-rolling mill.
And the manufacturer has not been co-noticing.
Not been co-noticing.
Where is the tribunal's order?
Well, a tribunal order, my lord, will find at page stay petition.
In still there is no order. Memo of appeal.
In the memo.
It's not there in the stay petition.
Stay petition. It is on the order.
Memo ta dinda.
Internal page 3 starts.
But how appeal is, oh, this is assessee, sir.
Am I?
Otherwise, it is barred by monetary limit, 26 lakhs overflow.
My lord, may I show your lordship rule 26 for once?
1 second.
Yes, my lord.
wrong question করেছে তো next 26 ডিপার্টমেন্ট মানে অ্যাপিল করেছিল মানে মনিটারি গ্রাউন্ডে ওরা অ্যাপিল করতে পারেনি বলে দুটো যে রেফার করছে
আরে মেবি সেগুলো তো ফাইনালে গিয়ে হবে এখন এটা তোকেও দেখতে হবে কেন হয়নি বা কি হয়, তাই না? তোকে ওটা চেক করতে হবে ওয়াই ইট হ্যাপেন্ড হাউ ইট হ্যাপেন্ড।
Rule 26.
Rule 26.
Page 4 of the tribunal, it's quoted.
Yes.
Any person.
My lord, the difficulty is this, my lord. That's what I want to show your lordship. My lord will kindly take the book. They have omitted the proviso part of subrule 1. They have given the subrule, then subrule 2. Kindly. My lord will kindly forgive me. I have only having one copy. My lord will kindly see subrule 1. There is a proviso. In the next page at the top. Kindly see that proviso. What the proviso says.
ম্যাটারটা কবে দেবে?
মানে 2012
এটা কবে দেবে? অ্যামেন্ডমেন্টটা কবে?
2015 হয়েছে পিরিয়ড হচ্ছে 2012
2012 ওটা ছিল?
হ্যাঁ ওইটা তো পরে এসেছে বইটা
ছিল আছে আমি বলুন।
হ্যাঁ ঠিক আছে, এখানে আমার সাথে প্রোভাইডার আমার এটা 2013। ও
Yes.
that provision is coming to.
Now, my lord, the other part, my friend will be able to appraise your lordship. But so far as Poroshnath re-rolling mill case is concerned, I have the knowledge, but I don't have any document to substantiate. That has been remanded to the commissioner, adjudicating authority. On the finding that the duty demand against them on those recovered documents, etc., are not sustainable. If that is that position, remand before the commissioner, then how a penalty upon me on 26 without making.
Here, it's a case of admission. That's
Admission,
what the
absolutely.
But I'll show your lordship. I'll show your lordship. Well, the first question of law before your lordship is this. That
See, the thing is, proviso will stand attracted if they are all co-notices.
If why? Well, that is my question.
But in the show cause notice, the reference is Prashanta.
Correct.
Prashant.
Poroshnath re-rolling mill.
Prashnath.
Correct. Well, that is my question of law, whether without making them a party, this proceeding can.
No, so far as the proceedings against this re-rolling mill, matter gone back to.
That is my knowledge. That is for the department to say.
Where is that other decision?
In Joy Balaji.
Joy Balaji.
Well, That is also with them, my lord.
No,
I am not a party over there.
most probably, my lord.
No,
Joy,
in your grounds you have raised.
Yes, I mentioned.
Then you should
Well,
be
I'll
having
bring
a copy.
I'll bring that. I'll bring that. Man, can you keep it tomorrow? I
Joy Balaji, most probably the department has not prepared appeal monetary limit. This is the issue has not been checked.
But I'll bring that. I'll bring that.
Or can the matter go back to the tribunal to see whether Jai Balaji
Yes.
can apply?
Yes.
Your lordship, my lord, in this order, the tribunal has categorically held they have never retracted their statement. They have never prayed for cross-examination of the persons from whom they have purchased the goods they are saying. Now the question,
But he says the co-accused.
he said co-accused. He is not a co-accused.
From broker
From-
and transporter, they are giving
My lord, your lordship will kindly come to page 3 of the tribunal.
Tribunal says the question thus remains whether the appellant can be held liable on the basis of statement tendered by co-accused.
Yes.
From the facts, it's observed that there are a large number of other pieces of evidence that corroborate the revenue stand.
My lord, kindly allow me to come back with the Joy Balaji order because my another senior friend is also saying that he had the occasion to appear over there.
In the such a seizure case with Joy Balaji, from the previous Joy Balaji.
My portion.
Different. The whole case
No, no,
tribunal has
first
on the basis of third party document, nothing. Absolutely involvement.
No, in respect to all other.
Third party document. They are saying it is recovered from the Balaji secret office.
Portion.
Their data was confronted before the appellate and appellate had admitted that yes, I have purchased without any invoice.
In some
It was confronted before him.
either selling or purchasing. Therefore, those transactions were held in cash. Therefore, you are liable to pay the duty. This is the whole thing.
My lord, allow me to come back with that order. My lord will see.
Here, my lord, here the case is only penalty.
My lord,
Here the
definitely
case
rule
is only
26 will only attract penalty.
only
But
penalty.
if there is no
Now-
confiscation order, how can be there penalty?
Now your lordship will kindly come to page 94. What are there is no
My
code.
lord has seen rule 26.
Page 94. What are the annexures?
If my learned friend wants to go to the fact, I can go into that. I can go into that to show that who has retracted, who has cross-examined, what has happened.
But tribunal from paragraph 5 proceeds voluntary statement of the
Yes.
proprietor.
That's an absolutely erroneous finding because in the case of Poroshna tree rolling mill, cross-examination was held. I have annexed that copy. In the cross-examination before commissioner, completely different thing came out.
Petitioner, sir, please take note. The appellant.
And in the appellate authority, what they have stated, my lord? Kindly see the appellate authority's order.
All right. The appellant places reliance on a decision rendered in another case pertaining to an assessee called Jai Balaji Industries, who's also a purchaser / supplier to
No, purchaser, only purchaser.
purchaser to Sri Parasnath, Parasnath, Re-Rolling Mills Limited, and the tribunal has allowed the appeal filed by Jai Balaji Industries. The learned advocate seeks time to produce the copy of the said decision and also ascertain as to whether any appeal has been preferred against the said order.
That for them.
Before this court.
Well, that my learned friend will ascertain whether they have filed any appeal.
We'll take
that one. The learned standing counsel for the respondent shall ascertain whether appeal.
কতদিন পরে রাখছে
কবে ডেট দিচ্ছি দেখুন
Next.
ডিলে কন্ডন করা
এখানে ডিলে নেই
ডিলে নেই তো ডিলে কোথায়
ডিলে নেই
ডিলে করিনি ভাই
কবে আসবে 10th মে
10th মে মানে ডিপ্লোমা
Item number 38.
আমি রেসপন্ডেন্ট এদিকে এসো
38.
Yes, Your Lordship.
That 38 is covered by the litigation policy. Only penalty issue, custom matter, less than quantum.
Kindly allow us to
We
take
will
it
pass a
back.
detailed order. We'll say so and so, Aishwarya Rajeshri argued, Ajit Chakraborty argued, etc., etc. 5-page order we will pass.
Lordship, we'll take instruction and come
No,
back.
no, don't. No commissioner will pick up the phone even. Where is you show the quantum. All cases like that. 38, 39, 40.
Yes, Your Lordship. All are covered.
This appeal, please take down, sir. This appeal filed by the revenue.
39 is different. My learned friend is appeared.
Oh, wait, one by one. This is under 35G, 35G of the Central Excise. Of the Central.
Oh, this is Custom Act. 130.
130, oh, Custom.
130 of the
130 of the Customs Act 1961. Is directed against the order passed by the Customs, Excise and Service Tax Appellate Tribunal, East Zonal Bench, Kolkata, in appeal numbers 7514, dated 31/12/2020. The revenue has raised. Where are your questions of law?
Questions of law, photo number, paragraph 1.
Page
That's
6.
page 17, Your Lordship. Yes,
B and C alone.
it is.
We have heard so and so for the appellant and Mr. So and so learned advocate appearing for the respondent.
Page 16 আছে না?
On perusal of the impugned order, we find that the penalty which has been imposed on the assessees where is the adjudication order?
My lord, adjudication order, my lord, will find at volume 2, page 183, ordering part. And the relevant part is at 184, paragraph Roman small 9. So far as this respondent is concerned.
Imposed on the assessee, which was set aside by the tribunal. Set aside by the tribunal, against which the revenues and appeal is far below the threshold limit fixed under the notification issued by the CBGT. Thus, on the ground of the monetary policy, the revenue cannot proceed. Consequently, the appeal stands disposed of on the ground of monetary limit, and consequently, the substantial questions of law which have been suggested are left open.
37, 38, same.
Not 37, 38.
38 and 42.
38, 39.
No, 39 not. 38, 42, 45, 47, 48, 49.
You write down and
yes, I have written. I have already written.
No, we are not.
We are not in all these matters.
Lordship, we are in 38 till 42.
Wherever you are appearing, you give the matter.
Lordship.
This is all borne out by records. The remaining, you call.
Number 39.
39.
39.
You show the order.
47.
Lordship, 39 is different, Lordship. I pray to your Lordship. We can take it up next week, Lordship.
Next week. 40. Wait, let him call out.
40.
Let him call out.
I know 40.
39, my lords.
Next week. Item 40.
I know 40.
Litigation policy. Same order, sir. Item 40 also. Next.
I know 41. It's litigation.
Litigation, yes.
48.
I know 43.
Lordship, in all the matters, Your Lordship, I'm filing the affidavit of service, Your Lordship.
Which one?
In
Previous matters.
Previous matters, Your Lordship.
All right. 43, who will appear?
43. I know 43.
Who will for the respondent? Mr. Banerjee is appearing.
Now, my lord,
Mr. Bosco.
the petitioner.
Read the brief.
Now, my lord, before taking my lord to the impugned order, my lord, what happened, my lord? During the COVID period, my lord, the petitioner was assessed by the adjudicating authority
and penalty was imposed without pre-consultation. Now, my lord, what happened, my lord, after that, my lord, we received a notice from the, my lord, authority demanding attachment of our banks, my lord. With that, we received the order in original. Now, my lord, we approached this honorable court challenging that, my lord, as but the writ court said you have an authority before the they have an appellate authority, you go back. Dismissed. You know, we went back to the appellate authority. We always asked to show us that whether you have served the copy of the order in original. My lord, they are not able to show that the copy of the order in original was served at any point of time, 7 except with the letter, my lord, showing that this amount is due, your bank and other things are liable to be attached. Now, my lord, the appellate authority, my lord, has passed the impugn order saying that since the writ court has passed an order, and my lord, authorities have said that the order in original was served without any documentation. My lord, we are not going to interfere. Your right of appeal is also not there. So today, my lord, I am at a juncture, my lord, where, my lord, I have become remediless. My lord, even I cannot proceed before the authorities on the ground of limitation itself. Where, my lord, from the if it is taken from the date from which the notice was served upon me, I am very well within that limitation period of 90 days. 60 plus 30.
Please show us the High Court writ petition order.
Yes.
158.
तो बोलेंगे ना सुनते वाले वाला जैसे
158.
Volume 1 is it?
Volume, second volume.
Page
158.
Writ petition order also. Order in the writ petition.
No, it's not there.
No. Not that.
152.
152.
Petitioners are seeking liberty to allow
Calculation
the
double
petitioner
to
file appeal was filed within a period of 60 days or so. Almost more than 7 months have passed from the date. Petitioner to show bona fide illness has not filed appeal. It is not the case of petitioner filed an appeal beyond time. Appellate authorities illness on the part is found to be flimsy now. It filed by another partner, and if you were to come to court, so also. But where have you said that the order in original was not served?
Now, my lord, order in original before the authority, my lord, we went there and said that you show us this service because you say
in the writ court.
Writ court, my lord, after receiving that demand, we approached. My lord, with an averment saying that we have received the order in original.
You should have, of course, the court said you are hopelessly time barred
Yes.
before the commissioner.
Yes, we went back to the commissioner and we said that you produced the order in original which was served. They are not able to show for a moment they have served the order in original.
Where is that letter?
Yes, that letter. Kindly takes up, my lord, page 135.
135.
Yes. Of the volume 1. So this is that letter of 31st of October 2022.
135 is
My lord, annexure B in the volume 1, my lord.
there are two
29 would want to
129, my lord, kindly. Pagination में गंडगोल है। मतलब 129 if my lord.
Okay, 120.
31st of October, my lord has got.
That is the proceedings of the superintendent.
No, my lord, it's a letter written by the, my lord, Superintendent, my lord, Haldia Division, Haldia CGST,
Yes.
31st of October. My lord, by which they seek remedy. For your convenience, a copy of the last portion, my lord, will find. For your convenience, a copy of OIO is enclosed for ready reference. So this was the first letter, my lord, by which we came to know of this order in original.
He does not deny that I have already served.
No, my lord, if from this date it is calculated, we are within time.
No, correct. You said you had addressed a letter.
My lord.
You had said, your argument is, you addressed a letter to the department after the writ was dismissed. Please give us the copy of the O&O.
No, my lord, we went before the authority and said, they say.
At what point of time?
My lord, after the writ was dismissed.
Yes. Where is your communication to them?
Oral. No, my lord, not oral, because at that juncture we challenged in the writ court on the basis.
After the writ petition was dismissed, what did you do?
Well, after the writ petition, I went before the appellate authority.
Where is the proof to show?
My lord, I filed an appeal, my lord, first appeal before the appellate authority. Kindly takes up the, my lord, volume 2.
You show that.
The page 154, the form ST4. The next page of the, after the writ court's order.
In the appeal memorandum,
Yes.
have you said that this appeal is within time because I have received the O&O only on this date?
Yes, the 31st of October.
Where have you said it?
But kindly seize. My lord, kindly takes up page 175 for a moment. My lord, this is the appeal before the Commissioner of Appeal 2, GST, where my lord specific stand in paragraph number 4 in my grounds of appeal.
175
page. Paragraph number 4. 3 and 4 together, my lord.
The grounds it is not there.
My lord, it's in the petition before the Commissioners of Appeal, where, my lord, paragraph number 3 and 4, my lord, we have said, we have urged before the authority that we have
Your
received
page
it on.
number is not tallying, sir.
Yes. My lord,
Where are you referring?
annexure P7, my lord.
Huh?
P7.
Something you file and throw inside.
Annexure G.
Well, the page numbers are not matching.
Well, I'm sorry, my lord, if page numbers are not, I'm extremely sorry, my lord. Ought to tally, my lord. Ought to have tallied.
Page 173.
Yes.
No.
That is statement of facts.
Yes.
In that, what you say is, I'm sorry, not 170, 175. Oh, 170, sorry. 150. 157.
পেজ নাম্বার গুলো গন্ডগোল হয়ে আছে।
Sorry, 162.
160.
Though the order was passed on 23rd, it could not be ascertained from a record the date when we actually received it. The status of tracking of the said letter sent by speed post was also not available. This is your stand.
Yes, my lord, that was there, my lord. Apart from that, my lord, the page numbers are not telling, my lord. If my lord sees me, I just hand over a copy. The specific assertion, my lord, is there before the authority. Yes, excuse me for the marking, my lord, that it was received on 31st, and my lord, we urge that we are within time if we have received on 31st only.
You please go by this number.
Very.
Not this number.
Very.
169. And the commissioner rejects your appeal on the ground of
That writ court has dismissed. Firstly, my lord, if sees the impugned order,
No.
doesn't wish to interfere because writ court has dismissed.
Where is that order?
My lord, kindly sees, my lord, page 262, 260, the last order, my lord, the last forum of appeal, my lord, after which, my lord, I am here, my lord. Page 262.
That is the tribunal's order.
Yes.
Under 205,
Commissioner's order.
205, 205. Kindly see paragraph number 2, where the commissioner, after checking the records, have come to a conclusion. Paragraph number 2.
Yes. As it appears from the office record, my lord, but where is that office record? My lord, till date, my lord, even before the, my lord, tribunal, we have definitely asked for that office record.
Banerjee, the impugned order has been issued on 23/3/20.
And duly communicated to the appellant.
When?
Whereas the instant appeal has been filed on 28th December
So
2000.
normally what you say is was issued on so and so date, dispatched on so and so date, and received by the assessee on so and so date. That is the normal language. This is smart drafting.
My lord, this is one aspect. Second aspect is no pre-consultation, my lord. Demand is more than 50 lakhs, my lord. It's almost 70 lakhs and odd. My lord, thirdly, my lord, even during the COVID period, no virtual hearing was granted. My lord, physical hearing was given through mails, they say, but they, in the order, my lord, before the adjudicating authority, they say, my lord, there is no reflection of virtual hearing being given. Absolutely during the peak hours of COVID. My lord, so today, my lord, I cannot even, my lord, even if I go into
And
the
one more thing, precondition, I mean, pre-deposit, you have not complied.
No, my lord, that was complied, that the tribunal has held. You have rightly deposited what was happening. My lord, in the portal, there was a trouble going because this is service tax. So whenever I was depositing, it was directly going to the, my lord, CGST, GST column. So I have deposited in that website problem, my lord, was rectified by the tribunal. That deposit was allowed.
Yes, sir.
Yes, my lord. Kindly come to page 177.
এই পেজটা দিতে মানা করছে, এই রেফারেন্সটা দিতে বলছে।
Some chance opportunity, sir.
My lord, 170 when my lord, kindly see, my lord, he has requested for installment. Kindly see paragraph number 4. Now,
Obviously, what to do?
we have granted him in installment on the next
threatening
page,
him, then you
185.
have invoked extended periods.
Yes.
So he has entitled to contest.
Now,
Let the
thereafter,
appeal be
in
heard on merits.
my lord, 185, we have granted him installments.
And how much of the
My lord,
installments he has paid?
my lord, they have used garnish and more than, my lord, as per
My
my
lord, we
oral
have been-
instruction, 15-20 lakhs have been garnished. And my lord, accounts are my seized now. My lord, in such a condition, my lord, my business is on the verge of stopping.
Now, how much has been recovered out of the total demand?
My lord, oral instruction written I have not. My lord, they say, my lord, 15 lakhs odd has been garnished out from my account.
71 lakhs was the total demand.
Yes.
Out of which, how much have you pre-deposited?
My lord, that 10% deposit I have given.
Out of
Pre-deposit.
71 lakhs, 10% deposited.
Deposited, and my lord, they have
37 has been paid. 5 lakh 37 page.
pay 5 lakh 37 additional, and more amount has been recovered. But that figure total comes to 15 odd lakhs, 15
That is pre-deposit plus
plus
recovery.
plus what has been taken out,
It will be more than 15%.
15%.
This appeal by the SSC is directed against the order passed by the Customs, Excise and Service Tax Appellate Tribunal, Kolkata, Regional Bench, Kolkata, in sorry, dated 11th August 2023, by which the appeal filed by the SSC was dismissed. On perusal of the impugned order, we find that the learned tribunal was largely persuaded to dismiss the appeal on the ground that the writ petition filed by the appellant before this court prior to approaching the appellate authority was dismissed. We find from the order passed in the writ petition in WPO 2985 of 2022, dated 23/11/2022, the court was not inclined to entertain the writ petition since the appeal was filed belatedly. However, what is important to note is that the appellant's consistent case is that the order in original was never served on them. There was no pre-consultation made prior to concluding the proceedings and passing the order in original. And since the matter arose during the peak of COVID-19 pandemic, an opportunity of virtual hearing ought to have been granted to the SSC. At the initial stage, no, for sure. After the disposal of the writ petition, the appellant had approached filed the appeal before the appellate authority. Wherein a specific ground has been raised that the SSC was completely unaware of the order in original and came to know about it only after recovery proceedings was initiated by the superintendent, TAR, Haldia 1 division on 31/10/2022. Thereafter, when a copy of the order in original was enclosed with the said letter. Therefore, the SSC contended that the time for filing the appeal commences from 1st of November 2022 and the appeal filed by the SSC before the appellate authority on 20th December 2022 is within time. This aspect of the matter was never adjudicated at any stage of the proceedings. Namely, before the learned writ court in the writ petition filed by the SSC, by the appellate authority, or for that matter, by the tribunal. The appellate authority, where is that order? 205, no? Printed page number.
205.
The appellate authority while rejecting the appeal on two grounds, namely on the ground of being barred by time, and secondly, on the ground that pre-deposit condition was not complied with. On perusal of the appellate order passed by the appellate authority dated 22/3/2023, we find a definite stand has not been taken that the order in original, which was said to have been issued on 23/3/2022, was received by the assessee, and the date of receipt has also not been mentioned. So far as the allegation that pre-deposit condition has not been complied with, the said finding of the appellate authority has been found to be incorrect by the tribunal, since on account of certain technical glitches, the pre-deposited amount has already got credited into another ledger, another electronic ledger. Thus, during the pendency of the proceedings, by way of garnishee order, further amounts have already been recovered. And as of now, the learned advocate for the appellant on oral instructions from his client would submit that more than 15% of the demand has already been recovered, and the bank account has also been attached, as a result of which the business of the appellant is in the verge of being closed down. Considering the peculiar facts and circumstances of this case, we are of the view that the appellant should not be left remediless. That is, should not be left without an opportunity to put forth his case on merits. More particularly when there was no pre-consultation notice issued.
Well, that is not
correct. Please strike that up. More particularly when the when the matter was decided during the peak of COVID-19 pandemic, and also the fact that the appellant contends that no opportunity of virtual hearing was granted by the adjudicating authority. Further, as noted above, approximately 15% of the entire demand has been recovered. And considering all these facts, we are of the view that one opportunity can be granted to the appellant to file the statutory appeal before the appellate authority. Accordingly, the appeal is allowed. The order passed by the learned tribunal and that of the learned appellate authority is set aside, and the appellant is directed to, and the appellate authority is directed to take on file the appeal filed by the assessee, and if required, the assessee is directed to file a fresh copy of the appeal petition. The appeal shall be entertained. Opportunity of personal hearing be granted to the authorized representative of the appellate assessee, and a decision be taken on merits and in accordance with it. It is made clear that this order has been passed considering the peculiar facts and circumstances of the case and not to be treated as a precedent. Next.
My lord has fixed any time within which I have to prefer and fresh up.
No, they'll get angry with you.
Well, at item number 45 to 49, well, these are to be taken up on Wednesday because we have to argue, because some of them are customs officers, so they are not following. Your lordship has said within.
Why you want to argue?
Yes, my lord.
Why?
Because these are the customs officers. Your lordship adjourned the matter on the last occasion because 3 are the customs.
Oh, this is not a monetary limit.
Yes, this is covered by monetary limit.
He is saying monetary. We are saying not. It is not a monetary limit.
No. If my
No. The CBDT notification doesn't say the accused should be assessee. Accused should be customs commissioner.
My lord, we have judgments. Kindly.
No,
there are some judgments. Kindly appreciate.
What judgments are?
Yes,
you show one judgment. Supreme Court.
Your lordship's judgment is there.
What happened to the disciplinary action?
My lord, বলতে পারি?
Promotion would have been given.
My lord, I will leave my senior, my lord. The disciplinary authority has passed the major penalty has been issued. Now they have challenged before the tribunal, and before the tribunal they are citing the order passed by this planet Sestate that Sestate has exonerated us. So on that basis, you also tribunal also should dismiss. Now another thing is that, my lord, on earlier occasion I have submitted before your lordship that if the monetary limit should not be as a condition, my lord, when there is a substantial question of law. I have cited before lordship the judgment of your lordship and the Madras High Court's order, my lord.
Wait. Now it is 3:30 resolution. So we disposed of all those matters also. Huh?
Yes. Well, Lord, we were not heard. Well, Lord, it was just my
So
greater
which
friend.
are the matters we have to retain?
Yes. Kindly give us an opportunity, thereafter your lordship decides.
Four matters we retain. We will see.
That is 45
to 49.
No, 45, 47, 48, and 49.
Four matters. Retain.
My lord will hear these matters again.
Again on
It
Wednesday.
will be in the list.
Very
grateful.
And no other matter which is monetary limit.
Not as.
You will have to tell.
No, I'm not filing going.
My lord, so far as 51, I'm the respondent. That is also in respect of monetary limit.
Monetary.
Yes, I'm the respondent.
51 who's appearing?
Ekta
Sinha.
Sinha. Yes, they are, my lord.
Asho. Yes, madam. Council is saying monetary limit.
Yes, my lord.
You want cakes?
Tribunal allowed on, dismiss their appeal on.
Question of law is involved because Rule 8 is the question.
Well, the question of constitutionally is not there.
Inseparable matter is pending before the Honorable Supreme Court, overlooking that the tribunal has passed the order.
So far as the point of constitutionality, that is not there. Even in the Unsecured, there is the point of constitutionality is not.
Monetary limit.
He is appearing. Yeah, addition we need. If your lordship kindly comes to page 23, this is the adjudication order, which starts at page 23. The relevant portion is at page
25,80,000. Some small time plywood dealer, interest 69,000. Why are you harassing them, sir? Leave them alone. 2018, 2018 order. Please come. This appeal filed by the revenue is directed against the order passed by the Service, Customs, Excise and Service Tax Appellate Tribunal, East Zonal Bench, Kolkata, dated 16th June 2023 in final order number 75725 of 2023. The revenue has raised the following substantial questions of law. Please see the questions.
page number 9.
Page 9, 1A and B. A and B alone, sir. This extract is not required. We have heard Mr. Kaushik Dey, etc., sir. We have perused the adjudication order of order in original, and we find that the monetary limit involved in the case would not permit the department to pursue the matter on appeal before this court in the light of the circular issued by the CBDT. Therefore, this appeal is disposed of on the ground of the monetary limit, and consequently the substantial questions of law are left open. Okay.
नाम दे दिए